Good afternoon, everyone.
Good afternoon.
Good afternoon,
Good
Judge.
afternoon.
Good afternoon, Your Honor.
And I would say happy sunny Saturday, but I don't want to rub it in.
Judge, I'm not sure if you heard just a minute ago us talking to the Spanish interpreter, Adriana. There's one individual, it's position number 9, Mr. Hernandez, that we've not spoken to yet. We will need a breakout room. Actually, Zachary Judd from our office will need a breakout room with Mr. Hernandez and the interpreter.
Okay,
And I've got the beginning of the calendar, so if we end up going in order, we could probably scoot out to do that.
okay.
Hey, Ms. James, just give me a second to try to coordinate that. I'm waiting for the other officer to come back. Once he comes back, I'll bring him to, he'll bring him to courtroom 3, where you guys can do the breakout.
Okay, cool.
All right.
Great, thank you. You only have one case for the interpreter?
That is correct.
Okay,
Yes, Judge.
And we're gonna have, whenever you're ready, add on 1, Ms. Janiah Dennis.
all right, I'll give my opening. And who do I have with me? I see Mr. Jordan. Oh, Miss Grace. I see the reset date, 3/16, okay. For SAP. All right, good afternoon, everyone. I'm Judge Regina Mincy, and this is going to be our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before state court judge, so we are able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. I will also be providing you with a reset date for SAP, which is March 16th, and I believe that's already in the chat. Also, I want to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. Govern yourselves accordingly. Also, I want to let the defendants know or inform you that you have certain constitutional rights. The first being that you have a right to have an attorney and representation at this bond hearing today. And I'm sure that everyone by now knows who your attorney is. Listen to them. I also want to advise the defendants that you have a right to remain silent. Anything that you state about the facts, the circumstances, or the occurrences regarding your case can and will be used against you. So I'm sure your attorneys will tell you not to speak today. This is not the forum for that. And again, govern yourselves accordingly. All right, first case we have is add-on 1, Janiah Dennis.
No.
All right, this is case number 23 CR 001242J. You're charged with 1 count of willful obstruction of a law enforcement officer, 2nd count possession and use of drug-related objects, 3rd count pedestrian in the roadway, and a 4th count of public drunk. Those offenses all occurred on March the 2nd, 2023. Pre-trial?
It's 5th arrest. She got an open shoplifting in Superior Court. 21 CP 203177. She was arrested twice in 2019, probation violation. 2021 trespass, dismissed.
All right. State?
Yes, Judge, this case is currently subject to a $5,500 total surety bond.
I can barely hear you.
I cannot hear her at all.
Yeah, okay, okay.
Can you hear me now?
Little better. I don't know. PD Jinx.
A little bit better, same judge.
I hear PD Jinx really good.
What about now?
That's better.
Okay,
Okay.
so this defendant's case is currently subject to a $5,500 total surety bond. It has a $2,500 surety bond on the willful obstruction, $1,000 surety on the possession of drug-related objects, $1,000 surety on the pedestrian and roadway, and $1,000 surety on the public trunk. This incident did occur on March the 2nd. Officers indicated that this defendant was in the middle of the road near 478 Edgewood Avenue, smoking crack with her pants down and drinking from an open can of beer while knocking on motorists' windows, asking them for money. Officers said that when they approached her to get her to leave the roadway, she began to tense up and was not complying with their commands. And therefore, when they were able to take her into custody, they also charged her with the obstruction for tensing up and not listening to their lawful commands at that time. Given the nature of the offenses alleged and this defendant's criminal history, we are going to be requesting a reduction to a $500 surety on each count, making for a total of a $1,000 surety, a stay out of the roadway in that Edgewood area, and no alcohol, drugs, and weapons.
All right, PD Jenks.
Judge, we're asking Your Honor to consider converting all of those bonds into signature bonds through pretrial. Ms. Dennis is 23 years old. She does live in Stone Mountain with her aunt. She does not have children. She's actually currently not working, so any kind of bond would be tantamount to no bonds for Ms. Dennis. She has no prior violent charges. And just from the narrative that the state just went over, it sounds like there's some argument related to some of these charges, particularly the obstruction. So we're asking you to consider a signature bond through pretrial, and even with a higher level of oversight if you're inclined to do that.
23 not working, or
She's just currently not working, Judge. She did, she's completed some high school. She's limited with her skill set, Judge.
She does have several probation violations, Your Honor, from 2019, and criminal trespass arrest, as well as an open felony theft by shoplifting. So given these circumstances, Your Honor, we do believe that $1,000 surety is more than reasonable in this case.
And Judge, just to clarify, I thought I heard that pretrial said one prior criminal trespass that was actually dismissed, and there was one probation violation in 2020. So I think that was a little inflated just now by the state.
It was two probation violations from 2019.
Oh,
Right.
two probation violations?
okay.
Correct.
I am concerned about the alleged conduct and whether or not she would need some assistance. But you stated that she lives with her aunt.
That's correct, in Stone Mountain, Judge.
I am going to grant the $1,000 surety bond, which is $500 on each of the charges. So I will reduce it to $1,000 surety bond. No drugs, alcohol, or weapons while on bond. And I think that will do it.
And Judge, are you saying 250 on each? Because there's 4 charges, so 1,000 divided by 4,
Yeah.
250.
Thank you for the math help. I needed that.
I'm not great at math, but I was just.
I was trying to make that come out to 1,000. I apologize. Yes, correct my math there, Miss Grace. Yes, 250 on each. Thank you. Anything else?
No, Judge.
All right, thank you.
Next, Your Honor, we're gonna go to position number 1, Ms. Coleman.
Okay. That is 23 CR 001235B as in boy. Javeria Coleman.
Come here. I say, come here. Go ahead, Your Honor.
I'm sorry?
You can finish up.
Okay. And Javeria Coleman, you're charged with 1 count of simple assault, family violence, and a 2nd count of simple battery, family violence, both with the offense date of March the 3rd, 2023. Pretrial.
Third arrest, 2016 forgery, dead docket. 2022 theft of services dismissed.
All right. State. ASG Duncan.
Yes, Your Honor. This incident did occur with, who I believe to be her child's father, Kyle Barron. That's K-Y-L-E, last name B-A-R-R-O-N. Officers were dispatched to that location. And they said that when they got to that location, they heard loud yelling from inside of it, a female stating that she hoped someone would die. When they were able to get inside the residence, they separated the party so that they could understand what was going on. They have children together. I believe it's a 3 and a 5-year-old child, and they live together at the incident location, which is 2131 Meador Avenue Southeast. It's indicated that they are not in a relationship. However, there was an incident because the defendant in this case had gone through the victim's phone and got upset because he was sending flirtatious messages to other people. And at that time, it's reported that she became extremely agitated with the victim in this case and started acting aggressively toward him. So he started to record what was going on, and she started striking him, breaking wine bottles and throwing alcoholic beverages all over the house. Eventually, his mother was able to get to the scene, and she stated to officers that the defendant in this case, my apologies, was making threatening messages towards the life of her and her son while she was there. The state is doing further investigation in this case, but given the facts at the current time, and in this case, we believe a $4,500 total surety is more than reasonable. That's $2,000 on the simple assault family violence and the $2,500 on the simple battery family violence. We understand that this defendant has limited criminal history, but we do have some concerns about the risk of reoffense, given that they share 2 children together and are currently still living together. We're further going to ask that there be a stay away from the incident location, no further contact with the victim, third-party child transfer, 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. As this did just occur yesterday, we do not believe that there has been a sufficient cooling off period, and we believe that our recommendation is more than reasonable under the circumstances.
All right. PD Jenks.
Thank you, Judge. We're asking you to consider a signature bond in this case. I hope I heard it right this time, that there are actually no prior convictions through pretrial. Ms. Coleman is 31 years old. She's born and raised in Atlanta, Judge. She does have ties to the community related to the Ayala factors. Her grandmother is here, and actually she can live with her grandmother, so there's no reason for her to return to the 2131 Meador Avenue location, although she does have all of her items there, including her car keys and her money and her purse. So I did talk to her about returning there one time only with law enforcement so she can gather her things, but she is able to live with her mother, and I have that with her grandmother, excuse me, in Decatur, and I have that address. My understanding is that she's completed high school, Judge. She's also completed some college with business administration classes. She works at Rainbow Clothing Corporation as assistant manager, and then also has a side business that is her own business doing website design. As the state said, they do share a 5 and a 3-year-old together. My understanding, Judge, is that she's got sole legal custody right now. Of course, we would want the third-party transfer in place so that if there was going to be any kinds of sharing of visitation, that could be effectuated by a third party. Again, I think I read in the police report that there were no injuries, Judge, or the warrant application, there were no injuries. And since she has a place to live, we are asking you to consider a signature bond in this case.
And I do believe that the victim is on the line and they would like to speak.
All right. Is this the victim, Mr. Kyle Barron?
Yes, hey, how's it going?
I am fine. Would you like to address the court today, Mr. Barron?
Yes, ma'am.
Hold on one second. I need to swear you in first. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down. What would you like to tell me today?
So we're doing this situation right now together. She's been doing really well. She struggles with some anxiety and mental things that we haven't seen in a long time. And given the circumstances, I think it triggered this kind of episode to happen. And I don't think, that basically I'm trying to hope for this, because right now, if we can't get a signature bond, it's gonna cripple us. Right now, we're in the process of moving. So I was hoping that we could do just a non-violent so that we could do this move efficiently. And basically my whole concern from the beginning was just for the kids. So I would like to be able to work it out with her in a different way with the kids, so that this isn't as drastic of a situation for us as a unit.
Are you in fear of Ms. Coleman?
I'm not personally in fear of her, no.
Okay. And you all have 2 children, 3 and 5?
Yes, Your Honor.
Okay, and these are your biological children?
One of them is, yes.
Okay. Which one is yours, the 3 or the 5?
The 5-year-old.
Okay. All right, any cross-examination, State?
Just briefly, Mr. Barron, hi, my name is Ms. Duncan. I'm a prosecutor with the Fulton County Solicitor General's Office. On the date of this incident, which was yesterday, did you report to police that the defendant struck you?
Yes, I did.
Did you also report to officers that she was throwing household items like broken wine bottles around the house?
She was throwing, she had a wine bottle, but she didn't throw it or break it up against anything. She was just throwing the liquid across the house, making a mess kind of situation.
Also, yesterday, did you report to officers that she threatened you?
Yes.
Thank you. Nothing further.
All right, PD Jenkins?
I mean, I was just perplexed about what just happened there, Judge, but no, I mean, it sounds like Mr. Barron is not in fear of Ms. Coleman. Again, Judge, she has no prior, I mean, essentially no prior convictions. She has another place to live. It sounds like Mr. Barron and she are trying to work out a situation, as he astutely stated. So we're asking Your Honor to allow signature bonds. We're fine with the anger management class if that's going to be a special condition. But again, she's got a place to live, and he is clearly under oath stated that he is not in fear of Ms. Coleman.
And Your Honor, I believe Ms. Annette Barron, who was also on the scene of the incident, who was called during the incident by the victim in this case, would like to speak as well.
And Judge, I'm going to object to that unless she's the alleged victim. In this case, we have what we need in terms of a bond hearing for Your Honor to make a decision and exercise discretion. So I'm going to object to any input from Annette Barron.
She also is likely a victim in this instance, Your Honor, too, because she was, as is reported in the warrant, she was also threatened at this time.
And is she a victim? You said likely, or is she not?
She was threatened. She was also threatened by this defendant. The state is looking further into what had occurred between the parties at that time to see if there are going to be additional charges. But she was there. She was called by the defendant. So we believe what she may have to say might be valuable to the court's evaluation.
And Judge, again, unless I've not provided with everything, I'm looking at a warrant application that only lists Kyle Barron as an alleged victim in this case, Judge. I mean, the state, of course, is, free to add charges up until the statute of limitations. But right now, this is what we've got in front of us, Judge.
Right. I understand the mother came on the scene afterwards or was called shortly thereafter. I don't think that I need any more testimony to determine bond at this point, because I understand that this situation is between Mr. Barron and Miss Coleman, who have a child together. Is that correct?
Yes,
And
Your Honor.
unless are you living with your mother, Mr. Coleman? I mean, Mr. Barron?
No,
Okay.
currently I'm living, I've got my own house, but I would like to also ask if possibly we could just do a non-violent agreement, because I'm not afraid, like the legal separations are gonna put a large strain on us as far as getting things together on behalf of the children. Me and Javeria both work almost 7 days a week, every week. We're 24 hours. It's either the kids or working.
Right.
And this is gonna further complicate things.
And I'm assuming your mother helps out. Is that what you were going to say to me possibly? Does your mother help out with the kids or something?
Yes, she does.
Okay.
She and we're in the process of moving some stuff around, and
Right.
but
I
yeah,
understand that. You've told me that. What I'm concerned about, though, is this just happened yesterday. And normally I'd like to be sure that everyone's going to be safe, especially you as the victim and the children are in a safe situation, that there has been ample cooling down. Usually it takes a little bit more than 24 hours, in my opinion, for that cooling down period. I understand that it may be a strain and a hardship on the household, but I want to put some things in place for safety and for there hopefully to be no future incidents and nothing beyond this incident. Okay. So I'm not going to hear from your mom at this point, because I think the situation seems to involve you and Miss Coleman mostly. Okay.
okay.
All right. So I am ready to give my ruling if there's nothing else from either counsel. And
I want to
yes.
clarify for the record, his mother was actually on scene and the warrant does indicate that himself and his mother had locked themselves in the restroom. That's why I believe his mother was going to speak during this incident to kind of avoid the situation that was going on with this defendant. Nothing further.
Okay, I will take that into consideration. The mother doesn't live with them daily, and I understand she came, so I'm okay with hearing that additional information. But as far as the bond goes, what I'm going to rule is a $4,500 signature bond through pretrial, and that will be $2,000 on the simple assault, $2,500 on the simple battery. And I'm giving this signature bond a little bit reluctantly, Ms. Coleman, but I am hoping that you will get some help and assistance so that you can have a good and healthy relationship with Mr. Barron, or the father of your child. I'm going to order you to take the 1-day anger awareness course with pretrial. I'm going to order no drugs, no alcohol, no weapons while on bond. And I understand that you're working and you have 2 children, but right now I think it is going to be best for everyone for a separation period. I'm going to have you to stay away from 2131, is it Meador Avenue Southeast, and go to reside elsewhere while on bond or until a modification happens. Also, I am going to allow you to go back one time with a police escort in order to get your personal belongings and things that you may need. And remember, you to go back with an escort, so you'll have to arrange that once you're released. Do not go back on your own. And if there's visitation allowed with the children, that will be conducted by a third party so that you don't violate the conditions of bond, which are going to be, at this point, I'm going to order no further contact with Mr. Barron until we can get a handle on the situation. So I'm going to do that for now. And you can
What
talk
does
to
that
your
do?
attorney about any future requests for modification of those conditions.
What does that mean as far as the children, who the children are gonna be staying with and everything?
Well, it seems like she has full custody. I've heard that they will be with the mother. And if there's visitation allowed with you, that it will be conducted with a third party, which sounds like could be your mother if she's the calmer in-between person to help the two of you, that it would be precipitated or assisted with your mother or any other third person. But right now, I want to make sure that there is going to be the cooling down period between the two of you. And so I don't want you to have any contact right now. And if there is conversations or things that need to go on regarding the children, that will be conducted with your mom or some other third party, a friend or relative who could help be the intercessory person interceding between the two of you for right now. She's got to take her anger management class. She will be reporting to pretrial while on bond and staying somewhere else with her grandmother, where else, until you all can get a handle on this relationship, okay?
Thank you, Judge.
And Ms. Jinks, I know that they have turned off the microphone there, and I know that your client had her hand raised, but I think you'll be able to handle
I'll
that with
address,
her.
yeah.
Yeah.
Yes,
All
she
right.
does have a question, Your Honor.
Okay.
It wasn't necessarily a question. Can our third party person not be a net, seeing as she is kind of like in the middle of all of this? I would very much rather it be a neutral third party, somebody who doesn't have any animosity against me or my children.
That is a
I mean, I
Right.
think her grandmother could serve the same purpose, Judge, is
Yes.
my
I
understanding.
understand. Yes, and
And her name is
since-
Majida Rashada.
Yes,
Okay.
and she loves him just as much, so.
All right, let's do that since the state did state
I-
that there's
I
a
would rather
possibility of additional charges or things of that nature, and she may end up being an additional victim, certainly a witness in the case, and I don't want to bring any more incidents or things to happen. So that is a very good point. Let's make it Majida Rashada or any other third party who is not involved in this case, okay?
Thank you,
That's
Judge.
generally what I would like, yes.
It could be, the problem with it being Majida is that she's biased towards Javeria, and there's a possibility that we're not gonna see the kids after this
You will
point.
surely
Okay, I mean, and Judge,
He
if
has
you
no
could,
problem with it.
Miss Coleman, if you could just be quiet for a moment. And Judge, unfortunately, and I think we're all aware, a lot of these cases really overlap with family law, court matters, which it sounds like
Mhm.
this is definitely broaching into that in a big way. So
Right.
I've actually spoken to Miss Coleman about moving forward with some kind of, in a family court related to all of these matters. And I just wanted to share that I think that this is, mushrooming into a different space than where we are right now.
I agree. Mr. Barron, you can seek some legal advice or representation. I don't believe, and I didn't hear that the parties have been married before. And so there's some family law matters or issues that you will need to take up. Sounds like if there's not been a legitimation with your child, that technically at the moment, you don't necessarily have the rights that you think you may have, but seek some legal advice on that. And if Ms. Coleman allows you to visit, you can visit. If she doesn't, you cannot unless you get an order from the court, and that would be the Superior Court regarding visitation. So it will be at her discretion right now. And I want to make sure again that we don't have any more incidents, okay? All right, thank you. That will conclude this case.
Thank
Your
you,
Honor, I'm
Judge.
sorry, what was that bond amount?
$4,500 signature bond through pretrial.
That's the total, correct?
That's the total, 2,000 on the simple assault, 2,500 on the simple battery. And that is per judge.
Thank you.
All right, thank you. Thank you, Mr. Barron
Thank you.
and Ms. Barron.
Next, we're gonna have add-on 2, Mr. Rashad Span.
All right, this is 23 CR 001243J. Rashad Span, charged with 1 count of theft by deception, offense date March 3rd, 2023. Pretrial?
Second arrest, 2019 shoplifting. He got PTI, and he's wanted out of Henry County for fraud.
Okay. All right, ASG Bickerstaff?
Yes, good afternoon, Judge Mancy. How are you?
I am good. As this is my first time meeting you, I think. I don't know. I can't
This is
remember.
actually our second time.
Okay.
Yes,
All right,
this is my
welcome
third
aboard.
time doing the C calendar.
All right, welcome aboard.
Thank you. So, Your Honor, actually, this case, we went ahead and accused it, but our office we wanted to avoid a Riverside issue, but we will be recommending this case to the DA's office for a felony because the amount in question is $1,600.
Okay.
So I
Have
thought
you-
that this started, excuse me, I thought it started out in Superior Court this morning and then it came back down here. I thought that's what we were emailed about. Was that not correct? I thought it was already there and came here.
It
Mhm.
was already there initially, but I think it may have been an error because as Ms. Bickerstaff will inform the court, there is a points value and a monetary value associated. And the monetary value, which is a statutory requirement, is above the misdemeanor requirement.
I see ASG McCutcheon there. And I don't know if she has anything else to add to this. Has it been accepted, rejected? Is it in limbo? Do we
Good
know for
afternoon.
sure?
Good afternoon, Judge. I'm not
Okay.
aware of it. I'm looking at the notes now to see exactly what, if any, paperwork is in the system. If the
Okay,
DA has sent it back to us, then as it stands now, it's a misdemeanor. I'll have to look to see whether or not we would send the case back to them for reconsideration if perhaps there's some issue that we wanted to bring to their attention that they were not previously made aware of.
Mhm.
But I'm still looking to see what, if any, transfer notes I may see in the system, Judge.
Okay, thank you for that.
And to clarify, Judge, my apologies, and I don't mean to interrupt, but I'm lead today. So what happened is that a couple of the cases were believed to be misdemeanors initially, so they were sent to us. However, upon further review of the case, we've discovered that it was in fact a higher value amount than previously presumed. And at that time, felony first appearance was over, so we did not send it back to avoid a Riverside issue so that this defendant could get the bond that they are afforded. However, given that new information, we do believe that this case may be accepted as a felony.
Okay,
I'm sorry, I'm not understanding because I'm looking at the arrest affidavit, which clearly says the amount is 1,600. And this package was actually sent to me by Mr. Jordan from the felony court. So I guess I'm just not clear why there's this idea that it may be bouncing back and forth. I guess just from my perspective, Judge Mincy, I would like to be treated and go and launch into a bond hearing related to the misdemeanor charge. Obviously, the state can do whatever they elect to do moving forward. But as far as we're concerned, I think this is a misdemeanor right now.
okay. I agree. Let's treat it as such. Let me hear a little bit of the facts. And then we will let PD Jenks present and I will set a bond based on it being a misdemeanor at this point. Okay.
Okay. Well, Your Honor, this incident occurred on March 3rd. It is where the defendant used Miss Kelly Ann Daltrey's Hilton Rewards account, knowing that it did not belong to him. And he used 159,000 points, which equals out to $1,600 worth of points. And for these reasons, we're recommending a $2,000 surety bond, a stay away order from 3450 International Boulevard that is in Hapeville, Georgia, which is the Embassy Suites, Your Honor.
Okay. And what type of card did you say it was? A rewards card?
Yes,
Not
it was
a credit card.
Right. It's a Hilton. He used the Hilton Rewards account. Like, so he had the number and used the account to get a room at the Embassy Suites.
I got you. All right. I'm clear now. And no relationship with the party, with the defendant and the victim.
Correct. No relationship.
Okay. All right. Okay, PD Jenkins.
Yes, thank you, Judge. First and foremost, Mr. Span disputes the facts as alleged by the state. He said that a third party had actually made the had booked the room, so he wasn't aware of any kind of fraudulent activity. Mr. Span is a 24-year-old young man, Judge. He did complete high school. He also did 1 year of college at Georgia State, focusing on sports management at Georgia State. He currently is working at Amazon as a driver and also is working as a side gig in security. So he does have 2 jobs. He lives with his mother, which I believe it's the listed address on the paperwork in Hampton, Georgia. So he is living there. We're asking you to consider a signature bond in this case, Judge, and nothing further. And again, just to reiterate, it was not a credit card that was utilized in this case at all. And moving forward, Judge, I don't know if the clerk is making notes in this way, but he won't qualify for our services moving forward.
Okay. All right, I am going to order the $2,000 signature bond through the jail. I'm going to order no drugs, alcohol, or weapons while on bond. And I'm going to order a stay away from 3450 International Boulevard, which is the Embassy Suites there in Hapeville. Stay away from that location and no further contact with the victim, Kellyanne Doctor. And I think that's all that I will need to order at this point. Anything else, counsel?
Not from us, Judge. Thank you.
All right, thank you.
Next, Your Honor, we have position number 2, Mr. Jorge Coronado.
All right, this is 23 CR 001238G. Jorge Coronado. You're charged with 1 count of promotion of organization, exhibition of illegal drag racing, and actually 2 counts of that. And the offense date is October the 16th, 2022, pre-trial.
4th arrest, 2022 driving without a valid license conviction, 2022 expired license conviction, and a 22 arrest for the same charges today. I don't know the case number to that though. I didn't see it in Odyssey.
Is that
Possible to be the
duplicate?
same? I was getting ready to say, it sounds
I'm
like,
not sure. Hold on.
okay,
It's the same case number.
It is,
same case number, okay,
Mhm.
duplicate,
but it's
okay.
2022 on the GCIC, right?
Well, this offense date is October 16th, 2022 on the calendar. It's just hitting now.
State, you can go.
Okay,
Yes, so this occurred on 10/16/2022, where the defendant promoted or organized illegal drag racing by collaborating with others to create a list of addresses to shut down traffic and encourage others to perform burnouts and donuts in 2 locations. The first location is 635 Whitehall Street Southwest. The second location on the same day in on the same day is 2055 Mount Perrin, PARAN Road Northwest. Your Honor, this activity is dangerous for our community, it's dangerous for our citizens. And currently, Your Honor, the defendant is on hold without a bond. And so we'll keep that as it stands.
So
On
The-
holds without a bond.
the GCIC says April 10th, 2022, State Patrol promotes or organized drag races. So it has an April date, April 10th, 2022. Just a FYI.
Okay. If you would hold on 1 second so I can see like why it's a little different over here.
But I don't see it in Odyssey, so I don't know where you went.
I'm looking at the warrants.
Yeah, that's the one. I'm talking about the GCI.
For GCIC?
Mhm.
Oh, let's see.
It's the first cycle.
Okay. Hmm.
Hmm.
Mr.
So you see both of them in there pretrial, the April and the October?
I don't see nothing from October. The first two
Oh.
cycles on the GCICI has got those charges, but it's the same date, April 10th.
Oh.
October, I see a driver without valid license out of Alpharetta.
Oh,
And
okay.
October 31st, driving without a valid license out of Alpharetta. I don't know.
And Judge, based on my review quickly of the criminal history, I see what pretrial sees. That the
Mhm.
April is the drag racing charges. The arrest is showing the Georgia State Patrol arrest with an April incident date. And then, of course, what pretrial just said about October from Alpharetta, that was a driving without a valid license arrest.
So, I mean, it sounds like it's bottom line, there's only one case involving these two counts of alleged promotion of drag racing. Is that right,
Right.
Michelle?
That's what I'm seeing. Yes, I see 4 cycles, but cycle 1 is the drag racing, and it's an April 10th, 2022 arrest, Georgia State Patrol. And then
It's,
there's a cycle 2, which is there's 2 cycles here, and both cycles have the same arrest date. So I'd have to look into the warrants to see exactly what that is. Is that what you're also seeing pretrial?
Correct.
Yes.
Yes, in the warrants, and I think maybe I was a bit confusing, but the warrants are for the drag racing that happened on the October date.
but I'm not sure. It doesn't sound like there was drag
Not
racing in the
right.
October date.
October.
Right.
Sounds like he may have just been pulled over for the invalid license. I don't know what the stop was for.
Well, in October, yeah, it was the driver without a valid license, but it wasn't on the 16th of October. But these warrants didn't get signed until January, so I don't know.
Wow.
Yeah, they got signed on the 13th
Of January of this year, of 2023?
Yes, the judge.
The warrants were signed. Oh, yeah, I do see that.
Yeah,
there's,
so I don't know.
yeah, it seems like there's some serious issue
Mhm.
with the paperwork here, Judge. Yeah, I didn't catch that.
I'm getting a feeling possibly that, And who issued the hold without a bond?
It was on the warrant, so it would have been the judge at the time.
Yes, the judge at the time was Judge
Higgins Brooks.
Yes, Higgins
Wait.
Brooks.
Judge, as you know, any misdemeanor, the defendant is entitled to a bond. When you're ready, I'm prepared to argue for that.
Okay. Anything else from the state?
Yes,
Think
Your
we-
Honor. We would like to place or recommend a $2,000 bond, $2,000 surety bond for the defendant, $1,000 each for each count. Your Honor, that's all.
Okay. All right, Ms. Jenks.
Thank you, Judge. I'm asking Your Honor to consider a signature bond in this case. Mr. Coronado, first of all, denies the allegation. I think there's some serious legal issues with the warrants and the dates that are a little wonky here, Judge. But outside of that, it sounds like he's got essentially no real criminal history. He's got up to 2 traffic infractions that pretrial talked about from 2022. He is 18 years old, born and raised in Atlanta, Judge. He lives with his grandmother, who he tells me, and he actually helps her because she has a heart issue, Judge. And right now he states to me that she's actually in the North Fulton Hospital. He works, he's still in high school, in the Independence High School, Judge, and he's got 1 more year left to graduate, but he also works on weekends when he's not in school to help support his grandmother. His uncle is also living in the house, Your Honor. So both of them help to support his grandmother. Gladys Yanis is her name. We're asking you to allow a signature bond in this case through pretrial so that there will be some oversight over him. but again, allowing him to get back to school. It sounds like he's had, no real serious criminal history. And again, he denies this allegation of creating a list of addresses as alleged by the state.
He is 18.
That's
Looks
correct.
like, okay, so pre-trial, he does not, but I think my concern was he is still in high school though.
Yeah, so
So
he
he's-
Oh, he's
he's
older, but he's
Right,
still
Cool.
a judge.
meaning he's dependent
what that
on
means.
some, even though he's working, is he working part-time? I'm assuming he's not working full-time, I don't think.
Well, he told me 30 hours a week for a painting company, Judge. I mean, but he is in school in Independence High School, which is.
Independence High School is different from regular high school.
Oh, is that an alternative school?
It is, Judge. It's like a school for second chances.
But he intends to complete it, I hope.
Yes, he does. I actually specifically asked him that, Your Honor, and he said he has 1 year left to graduate.
Okay.
But again, more importantly, he is helping his grandmother at a few different levels, both financially and with her health issues.
I would like to do a signature bond through pretrial. I just need to know pretrial, from pretrial, if he needs a cosigner or not.
I mean, being in school, he would, but it's up to
I
you.
know, but the fact
It
of.
don't sound like the grandma can do it, so who else is
Right.
around?
Okay, right. Does he have any other relatives around? Well, you said the uncle lives at the house?
Yeah, but my understanding is he actually has medical issues also, but he is not in the hospital. I think when I looked at the pretrial report, Judge, this is one that did not say it needed a cosigner. Am I wrong?
They miss it from time to time.
They missed that. I mean, because I think I was specifically looking for that. I mean, or Your Honor, the alternative is to allow it through the jail.
Yeah, I would like to have some monitoring. So I'm going to allow it through pretrial and waive the cosigner.
Thank you, Judge.
That would be that $2,000 signature bond through pretrial,
Is that each or what?
1,000 each charge, total of 2. I'm going to order no drugs, alcohol, or weapons while on bond. And I'm assuming, I'm going to say as well, no driving unless you have a valid driver's license from DDS. I know that was last year, but I don't know if you've had time to cure what the issue is with your license.
I'm trying to get that fixed right now, so I haven't been driving at all. It's been
Okay,
a good.
do not drive then until you get your valid driver's license. And they will give you the information on reporting to pretrial. Anything else, counsel?
No, thank you, Judge.
All right, thank you.
Thank you, Your Honor.
Uh-huh.
Your Honor, next, we're gonna go to position number 13, Ms. April Mitchell. Come on, Ms. Mitchell.
Can I just check in about the interpreter case? Were you guys able to go to a breakout room, or does that still need to happen?
They get the breakout.
Okay.
I just need to do her real quick, Ms. Jenks.
Okay, no, I just wanted to make sure it was covered.
Yes.
Okay.
Issues here. Come on, Ms. April. No, sit down. You gotta sit down. Good job.
This is 23 CR 001227C, April Mitchell. You're charged at 1 count of criminal trespass. The offense date is March the 3rd, 2023. Pretrial.
7 total. 2021 trespass, you play a NOLO. That was the DeKalb County. Before that was 2011 possession of cocaine, dead doctor. Everything else is older.
Okay. All right. And state, I have, all right, ASG Bickerstaff.
Yes, so this offense happened yesterday at location 144 Walnut Street Southwest in Fulton County. And it's where the defendant was sleeping on Mr. Cecil Hill's porch without authority, despite him asking for her to leave his residence. The defendant has in fact been charged criminally for trespassing at his residence before in case number 23-059-2430. And for these reasons that the defendant has done this before at this exact same residence, we're asking for an $1,000 surety bond, a stay away order from the location 144 Walnut Street. We're asking for a no further contact order with Mr. Cecil Hill, no alcohol, drugs, or weapons, and MHET.
All right. And this is Zachary Judd.
Yes, Your Honor. Nice to meet you.
Nice to meet you. You're the conflict defender?
No, Your Honor, I'm one of the public defenders.
Oh, I'm sorry.
with you
One
to
of the
the
PDs
office.
as well. Okay. Nice to meet you.
Nice to meet you, Your
All
Honor.
right. You may
Your Honor,
proceed.
Ms. April Mitchell was unwilling to consent to any of my interview questions. I was unable to proceed with that interview. If she's changed her mind, I'm willing to go into a breakout room, but if she continues to refuse, I believe she'll need to proceed pro se.
Excuse me, I did ask a question.
What is she saying, Deputy? I can't hear.
Excuse me, I did answer the question. I did answer all the questions. I've been to court already. I don't want to have nothing to do with that. I did answer all the questions.
Do you want his representation, Ms. Mitchell? Do you want Mr. Judd to represent you today? Is that a yes or no?
Represent me today.
If this is a bond hearing, do you want public defender,
Which day
Mr.
is-
Judd, to represent you?
Which day is,
I'm sorry?
is it, ma'am, to represent me? Which day is,
Which day did you say?
yeah, which day is?
He's going to represent you today. You've been charged with 1 count of criminal trespass
All right, I
from
want
yesterday.
to know when I'm tell my part. I don't want to be bothered with that. Brought me to jail, took my ID from me. I had my ID.
No, but you're not answering my
I
question.
wasn't on that property. I was just sitting down to sit down. It's not against the law to sit down for a minute.
Your Honor, it
Okay.
makes sense to go into a
I
breakout room.
explain myself. They're not going to take me on. But anyway.
I think what I'm going to do,
I was just walking to sit down for a minute. They
okay,
stopped
no,
me
I'm not asking about the facts of your case.
like that.
This is not your trial, just trying to see.
But
if
I've
you-
done that already. Just trying to
Okay.
explain
I'm
my,
going to,
I'm gonna speak my.
can you mute her, deputy? Okay, I'm going to order a MHET. And I'm going to give her a $1,000 surety bond. And let's see what comes back with and no drugs, alcohol, or weapons while on bond. Mr. Judd, let's just do that. Because I think there seems to be some
Yes, ma'am.
serious concerns and issues here. And I think she's
Yes,
still
ma'am.
talking. So let's do that. Let's order the MHET, send me an order for that. And then we can see about getting her some assistance.
Yes, Your Honor.
Okay, thank you. I'm gonna let the deputy know. I'm sure he's gonna come back and. Deputy, that's a $1,000 surety bond.
I got it. I heard you.
Okay, oh, good. Okay, thank you.
Can we go to the interpreter case?
Yes. Oh, were they able to talk?
Yes.
Oh, okay, that was quick. Okay.
Your Honor, before we move on really quick, just for the previous case, April Mitchell, we're gonna do the $1,000 surety bond with the stay away, the recommendations and stuff.
Oh,
from the
yes,
state.
I'm sorry, the stay away and the no further contact. Yes,
Yes, and also no alcohol, drugs, weapons, and a MHET.
correct.
Okay, all right, thank you.
Thank you for the clarification.
And this is gonna be position number 9. Mr. Juan Hernandez, Juan Carlos de Jesus Hernandez.
Esta es la posición 9, el señor Juan Carlos de Jesús Hernández.
Let me swear you in, Madam Interpreter. Raise your right hand for me. Do you affirm to interpret? Is this, I didn't ask, is it Spanish? to English?
Yes, ma'am.
I'm sure. From Spanish to English and English to Spanish to the best of your ability with no embellishments?
Yes, I do, Your Honor.
All right, thank you. All right, this is case number 23 CR 001228F.
Este es el caso 23 CR 001228F.
This case is with Mr. Juan Carlos Hernandez,
El caso del señor Juan Carlos de Jesús Hernández,
charged with one count of DUI less safe,
con un cargo por manejar incapacitado por los efectos del alcohol.
second count of driving possession of open alcohol container,
El segundo cargo por tenencia de envase de bebida alcohólica abierto.
third charge of driving improper or erratic lane change,
El tercer cargo por manejo negligente o cambio errático de carril.
and the fourth count of expired or no license on person.
Y el cuarto cargo por no llevar licencia de conducir o llevar licencia vencida consigo.
All with the offense date of March 3rd, 2023.
La fecha del incidente fue el 3 de marzo del 2023.
Excuse me, Judge, one moment. I'm sorry to interrupt.
Yes.
This is actually Mr. Judd's case, and I think he got kicked out of the Zoom and is trying to get back in. So I just really wanted
Oh,
to
okay.
make sure
Let's
that
hold
the
a second.
host will let him
Right.
back in if that's what is holding him up.
Okay,
It says he's
Oh,
texting,
he's
that he's
back.
waiting to be let in.
He's back.
Okay, great. Thank
There
you.
we go.
Sorry about that, Judge.
gotcha, no problem. All right, you're back.
So sorry about that, Your Honor.
Okay, so we've only read the charges up to now and we're ready for pretrial.
Second arrest, 2012 driving without a license conviction. That's all I saw.
Este es el segundo arresto. En el 2012 hubo un cargo de manejar sin licencia.
All right, state.
Yes.
Fiscalía.
So this offense happened yesterday at Alpharetta Street in Roswell.
Ocurrió ayer en Alpharetta Street en Roswell,
Where officers observed the defendant failing to maintain his lane on Alpharetta Street.
donde los policías observaron que el acusado no podía mantenerse en su carril manejando por Alpharetta Street.
When officers stopped the defendant and approached the vehicle, they could smell alcohol coming from the vehicle.
Cuando el policía detuvo al acusado, pudo oler el aliento alcohol que provenía del vehículo.
And officers noted that the defendant had bloodshot watery eyes.
También los policías observó que el acusado tenía los ojos enrojecidos y vidriosos.
And the defendant actually admitted to officers that he had drank a Bud Light that night.
El acusado admitió ante los oficiales que había tomado una Bud Light esa noche.
And officers saw the can in the vehicle.
Y el oficial vio la lata de cerveza dentro del vehículo.
The defendant admitted to the officers that he was in fact driving without a license that night.
El acusado admitió a los oficiales de policía que estaba manejando sin licencia esa noche.
And when officers asked the defendant to exit his vehicle, he was visibly unsteady and unable to perform the horizontal gaze test.
Y cuando los policías le pidieron que saliera del vehículo para examinarlo, se pudo observar que no podía mantener bien el equilibrio y tampoco le pudieron conducir el análisis de la mirada horizontal.
And the defendant was also unable, the defendant refused to take the breathalyzer test, the breath test.
Y el acusado rechazó tomar el análisis con el alcoholímetro.
And for these reasons, we're asking for the bond that has already been set to stand. It's a $9,000 surety bond.
Por ese motivo, nosotros, la Fiscalía pide que se mantenga la fianza establecida de $9,000, fianza bajo garantía.
Yes, $3,500 for the DUI, driving less safe.
Serían 3,500 por manejar incapacitado por los efectos del alcohol.
$1,500 for driving with the open container.
1,500 por tenencia de envase de bebida alcohólica abierto.
$2,000 for improper lane change.
Y $2,000 por el cargo de manejo negligente o cambio errático de carril.
And $2,000 for driving with no license.
Y $2,000 por no llevar licencia de conducir.
We're also asking for no alcohol, drugs, or weapons while on bond.
También pedimos que quede prohibido el uso de drogas, alcohol y armas mientras esté libre bajo fianza.
And we're also asking for no driving at all while out on bond.
Y también que quede totalmente prohibido el manejar mientras esté libre bajo fianza.
That's all.
Eso es todo.
All right. PD Jed,
Yes, Your Honor. Senor Hernandez is 39 years old.
Sí, su señoría, el señor Hernández tiene 39 años.
He's lived in Georgia for the past 16 years.
Él ha vivido en Georgia durante los últimos 16 años.
Your Honor, he has a 16-year-old son for whom he is financially responsible, and thus he does need to keep working.
Él tiene un hijo de 16 años a quien él mantiene, por lo que él necesita seguir trabajando.
Your Honor, he has no similar priors, no felonies, no violent or sexual crimes, no failure to appears.
Él no tiene ningún antecedente relacionado con la violencia sexual o la incomparecencia ante un tribunal.
He's not currently on probation or parole, and this is the first offense of this kind.
Este es la primera vez que comete una infracción de este tipo. Él no está bajo probatoria o libertad condicional.
Your Honor, as a DUI trained attorney, I can tell just from the police report there are already issues with how they're saying the field sobriety tests were administered.
Y su señoría, con respecto al cargo de manejar incapacitado por los efectos del alcohol, en el informe policial se ven ciertas inconsistencias, problemas con el tomar el análisis en el área al acusado.
Your Honor, I'm unfamiliar with this officer Christensen or Salate as being DUI trained, that is NHTSA trained officers in recognizing impaired driving.
Y con respecto al oficial Christensen o Chete, también no parecen estar entrenados en analizar el manejo bajo la intoxicación.
Your Honor, the smell of alcohol is easily explained by the admission of one drink.
El olor a alcohol del vehículo se explica con la admisión de haber bebido una bebida alcohólica.
It's not illegal to have a single drink and drive, such as a glass of wine with dinner or a beer at lunch.
No es ilegal tomar una bebida alcohólica y manejar, como sería un vaso de vino o otro tipo de bebida.
It is only illegal to drink to the point of excess so that it is unsafe to drive.
Lo que es ilegal es el exceso en tomar una bebida, lo que no asegura el control de la persona al manejar.
Your Honor, due to the language barrier, I do find it likely that there were issues in the instruction portion of the field sobriety test.
debido a la barrera del lenguaje, he observado que hubo problemas en la comunicación de las instrucciones para que se realizara el análisis de sobriedad.
Furthermore, Your Honor, typically the implied consent card is only read in English, even if there is a translator present, which clearly creates an issue if Mr. Hernandez only speaks Spanish, which he does.
Con respecto, además, con la lectura del consentimiento implícito, se puede hacer con alguien que hable en español y esté en el lugar, pero eso no fue lo que pasó y realmente ese es el lenguaje que el señor Hernández habla.
And for these reasons, we would be asking for a signature bond today, Your Honor.
Por esos motivos, requerimos que se otorgue una fianza bajo firma a su señoría.
Your Honor,
Su señoría.
PD Judd's statement, this is not a field sobriety, this is not trial. His comment about the field sobriety test, this is not trial. So the officer had probable cause based on the warrant. Furthermore, PD Judd's comment about the warrant being read in English and Spanish. Again, this is not a trial. That's something we code take up later, not for a bond hearing.
Okay, one moment, please.
I'm sorry.
Con respecto al abogado de la defensa, señor Judd, no estamos en un juicio con respecto a la presentación de cómo se manejó la examinación de sobriedad, pero los policías se basaron en la orden de arresto. Además, el formulario fue leído en inglés y en español. Go ahead, man. Thank you.
Yes. His comment about whether the Miranda rights were read in English or Spanish, again, this is not that is an issue to take up at trial. It's sufficient for the probable cause for the warrant.
Con respecto a que cómo se le leyeron los derechos constitucionales, es una cuestión que se debe llevar y presentar en un juicio. No es nada que esté relacionado cuando se está peticionando esta audiencia de fianza.
Your Honor, if I may.
¿Puedo hablar, su señoría? Sí.
I find it only fair that if the prosecution is allowed to bring up allegedly not doing well with Fields and allegedly refusing the implied consent, that I be allowed to point out possible issues with those.
Yo lo que presento es que la fiscalía alega y a lo que alego es que no son buenos para realizar ese análisis en el área y también para ejecutar la correcta lectura del formulario de consentimiento implícito.
I understand. We'll move on from that. Did you tell me too that the defendant is working?
Yes,
muy bien, vamos a seguir. Usted me dijo que está trabajando el acusado. Sí, su señoría.
All right.
Muy bien.
I think I have enough information to rule on the bond.
Creo que tengo suficiente información para dar una sentencia acerca de la fianza.
And I'm going to order the $9,000 signature bond. And I'm going to...
Oh, I'm sorry.
Go ahead.
Voy a anunciar, voy a dar una fianza de $9,000 bajo garantía.
With the same breakdown as the state. With $3,500 on the first charge.
Y con la misma cálculo que presentó la fiscalía y por el primer cargo, $3,500.
$1,500 on the second charge.
Por el segundo cargo, una fianza de $1,500.
$2,000 on the third and fourth charge each.
Y $2,000 para el tercer cargo y $2,000 por el cuarto cargo.
So that signature bond will be through the jail. I'm going to make the conditions no drugs, alcohol, or weapons while on bond.
esta fianza va a tener que procesarse a través de la cárcel y es una fianza bajo firma y queda prohibido el uso de drogas, alcohol y armas mientras esté libre bajo fianza.
And I believe that I heard a 2012 driver's license conviction. Did I not?
Creo que escuché bien que hubo una sentencia en el 2012 por manejar incorrectamente.
Can anyone confirm that?
¿Alguien
Yes,
me lo puede
I wrote
Correct,
that down
correct,
from
correct,
what
correct.
pretrial.
Sí,
That
yo
is
lo
correct.
escuché.
Okay, because I believe that PD judge stated that he didn't have any other similar charges. I know it was a 2012 driver's license conviction. And then we have the charge here, expired or no license on person. So I am going to say that there will be no driving while on bond, except to, and the exception will be to go to work or to see his attorney or for medical services.
Yo veo que también lo que hubo en el 2012 acerca de una convicción sobre manejar sin licencia y ahora hay otra, yo creo que estipulo que no debe manejar y también no sé cómo se dirigirá el abogado acerca de esto para permitirle ir al trabajo o por razones médicas a un hospital.
Therefore, any pleasure driving or any other driving should be done through ride shares or someone will have to drive him.
Entonces, cualquier otro tipo de manejo para ir a buscar entretenimiento o otros por propósitos debe ser hecho a través de un alquiler o pago de servicios de transporte.
All right, is that clear?
¿Ese
That is
está claro?
If it is, then that will conclude this case.
Si está claro, esto concluye el caso.
Senor Hernandez, I believe the judge is asking you if you were clear on that.
Señor Hernández, creo que la jueza le estaba preguntando a usted si usted entendió todo claramente. ¿Dijo que sí?
Sí.
Yes.
See. All right. Thank you.
Muy
And-
bien, gracias.
And Your Honor, if I may add just for the record, Mr. Hernandez does not qualify for our office, so our representation was only for the purposes of bond.
Okay.
Y también,
Thank
si
you.
puedo dejar esto grabado para el acta, el señor Hernández no cumple los requisitos para recibir los servicios de abogado público, pero lo he asistido por el propósito de ayudarlo a obtener una fianza.
All right, that will conclude this case. Thank you.
Muy
Thank you.
bien, esto concluye su caso. Gracias. Thank you, Your Honor. May I be
Thank you.
dismissed?
Yes, you may. Have a good weekend.
You too. Thank you.
Thank you.
Next, Your Honor, we have position number 4, Mr. Gilberto Garcia.
This is case number 23CR001236E. Gilberto Garcia, charged with 1 count of reckless conduct. The offense date is March 3rd, 2023. I understand this is his first arrest from pretrial. So state, you may go forward.
Yes, Your Honor, this incident did occur yesterday at the Whitney Apartments. I believe that is 5555 Roswell Road. Officers responded to multiple calls of gunshots at the scene. And when they got there, they met with Rodolfina Navarrete, who is a resident of apartment W5. When they met with her, she was trying to indicate to officers that her apartment somehow was involved in all the shooting that had occurred. It's indicated that one of the victims in this case is James Montgomery, who is a neighbor of that residence. What's indicated to officers in the warrant is that there were several occupants of the apartment, as listed previously at the Whitney, W5, and one of those occupants was a defendant in this case. He apparently shot an AR-15 through a window with closed blinds. He told officers that he believed that someone may have been shooting at him. They're further investigating this incident, Your Honor, but we understand that this defendant does have a fairly limited history. However, given the nature and severity of shooting a gun in a crowded complex, specifically a gun such as an AR-15, which, as you know, or if not, is an automatic rifle, that is a higher grade caliber weapon and is very dangerous in congested communities. And given the state's concern with the rising gun violence going on in our communities, we have a particular concern for the citizens of Fulton County, and we believe that this defendant is a danger to the community and himself with these type of reckless behaviors. Given that he did shoot that gun outside the window, as officers were able to note in the warrant, with the blinds closed, and so I'm not sure how he would be able to see if someone was in fact shooting at him, and if there were shooting, all of the conduct was reckless regardless. For those reasons, and the state concerns about gun violence in our communities, we're going to be requesting a $10,000 charity bond. We're also going to be requesting a stay away from the incident location, no alcohol, drugs, weapons, specifically no firearms, and no further violations of Georgia law. Your Honor, this is just an egregious occurrence. AR-15s should not be shot out of windows in crowded apartment complexes such as the Whitney. So given these facts and circumstances, we believe the state's recommendation is more than reasonable.
All right. PD Jenks.
Thank you, Judge. Judge, we're asking you to consider a signature bond in this case. Mr. Garcia doesn't have any criminal history. He is, actually, I don't recall how old he is, but he's in 10th grade at Riverwood High School, Judge, in Sandy Springs. He lives with his mother, stepfather, his older brother, and 2 younger sisters. There is language in this warrant that there were several men with guns outside the apartment complex when this alleged incident happens. I suspect that when we dive into this case, Judge, there's going to be a pretty solid, a solid defense in his case, Your Honor. He does live with his family. I'm not sure why the state would want to stay away order from there, as his only place that he can live as a 10th grader, currently in high school. I did mention to him, I did see that pretrial approved him in terms of a signature bond, Your Honor. We're going to ask you to go along with that recommendation. And my understanding is, after speaking to him, that his mother, who's also listed on the jail screen with her current phone number, is willing to co-sign if Your Honor is inclined to have that happen. So we are asking you for a signature bond so he can get back to school and back to his family. And I suspect that this case will again be litigated when it hits a division court.
And Your Honor, as a 10th grader, that makes this situation even more dangerous for the particular victims and the defendant in this case. We were unaware of his living situation, as there were multiple people with guns in the apartment, which raises our concern about the nature of the offenses alleged. Further, as previously stated, we are unsure about, we would ask a stay away. However, we would defer to the court given the nature of his age in this, but we don't want to reduce the fact that these offenses have alleged to occurred in the manner as stated.
Okay, Ms. Jenks, we have another, as I say, borderline. We've got, he's 18, it looks like. I've done my math correctly. From what I see is the date of birth, but he's again in high school. I think like your other client.
I'm 17.
Yeah, I was about to say he's
He's
17.
I think
17.
17. Oh, that's right, 17. See, I told you, couldn't do the math. So you're 17. So he would have to have a cosigner. And what is his mother's name? Who's
His
on?
mother is Rhoda, Roda Navarrete, Navarrette, Judge.
I don't see anyone with that name on. Is she still on?
Oh, I don't know that she's on, but I know that I asked him if she was going to be willing to co-sign, and he had stated that she was. And her address and phone number on the jail screen there.
Well, it's interesting. It's not a handgun that is alleged. It's an AR-15. So my radar goes up. It's a very serious weapon, even if, the facts, I don't know how they're going to come out, but if there's folks living with him that have those types of weapons and he's around, I want to make sure that he doesn't have access, obviously.
Well, Judge, I suspect that a bond condition, that you would enforce is no, drugs, alcohol, or weapons, Your Honor. So he'll be on notice that that's the case.
And Your Honor, respectfully, the state would also like to request additional conditions of the court's bond, that being that this defendant provide proof that he is either in school, or if he's not in school, that he is working on a GED, and that he is also actively either employed or seeking employment.
He goes to Riverwood High School.
Well, if he can provide proof of that.
Show proof, sure, that's fine.
He can provide proof of that, and that he continue to attend school while he is on bond, or alternatively work towards obtaining a GED while he's on bond pending the resolution of this case.
I would certainly agree with that. I normally do want to make sure they're either in school or working on a GED.
We're in agreement with that, Judge.
Okay. I'm still a little concerned about the signature bond, but I don't, 17 years old. Hopefully he's not the one that had the gun, but I'm going to go ahead apprehensively, cautiously, and I hope that Mr. Garcia understands me.
I just want to clarify before you rule, he is alleged to have been one of the persons shooting that AR-15.
Judge, is this going to be a bond through pretrial, or is the court ordering a signature bond? The state is very concerned, as the court said, not only a handgun, notwithstanding the type of gun, any gun possessed by this defendant would be a violation of the law. But this was an assault rifle, according to the allegations. So the state is very concerned, and that there were multiple persons with guns at that particular residential area. So again, the state would reiterate its request to the court that this be some other than a bond other than a signature bond. If the court's inclined for this defendant to go through pretrial and he has conditions and he reports to pretrial, but the state is vehemently opposed to a signature bond, Your Honor, respectfully.
And Judge, so I can weigh in on all of that. We're asking that it be granted through pretrial. We understand that you want to have some eyes on this young man. We're fine with the added conditions related to his schooling. And there is language in here that there were several men outside of this apartment complex that were not living inside the apartment at the time that also had several guns. Again, I think that this is a situation that's going to have to get ferreted out, later on down the line in division. And again, I suspect that Mr. Garcia will have a pretty solid defense from my understanding of our conversation. But again, with that being said, he is a high school student. We're happy to have him provide proof of that while he's out on bond, and any other kinds of conditions that you deem necessary and relevant for this 10th grade young man.
All right. I have considered both the state and the PD's argument. And what I'm going to order is the $10,000 signature bond through pretrial. And Mr. Garcia, I'm going to be very as strong as I can be, and hope that you understand how serious this is. And my gut tells me not to do the signature bond, but you are 17, and I'm going to hope that the facts don't pan out to be true. But if they are, then you will have to suffer those consequences. But there will be serious conditions placed upon you. And the first condition is of this signature bond through pretrial, you will have to report to pretrial. Pretrial, is this going to be once a week or twice a month? What level will it be? I know they don't do that anymore, but
what level you want?
I wanted to report once a week.
Judge, and the state would request that. I know typically with misdemeanors, there's no level of supervision, but the state would request that the court order a higher level of supervision for this defendant if the court is going to grant the signature bond. Thank you, Judge.
Right. Yeah, I definitely want him to report weekly.
Do you want to report weekly?
Yes, I want him to report weekly.
All right, make sure it's on, have her to put on the bond order. So,
Yes, Ms. Grace, make sure that is on there. He's to report to pretrial weekly. He is to have no drugs, alcohol, or weapons or firearms in his possession, nor is he to be around any firearms. So he may have to find someplace else to live if everybody in the location has guns, because he can't be there. And if he's there and around them and the police come in and he's there, he'll be arrested with this $10,000 bond. So do you understand me, Mr. Garcia?
Yeah.
If you go home and your uncles and relatives, friends, whomever have guns, you need to walk away.
None of them have guns. None of my family members.
He understands, Judge.
Okay. And I'm going to require that you attend school, high school.
Yeah.
If you're not attending high school, I would say Riverwood since you're there, but I won't go that specific in case you have to move and change to a different school, but you should be actively attending school pre-trial. He should be showing you that proof that he is registered in high school. If he's not registered in high school, he should be in a GED program.
Put it on the order.
Okay.
What's the mother's name? Who's supposed to co-sign?
It's Rhoda. I'm
Spell
sorry, Judge. Yep. Roda Navarrete, Navarrete.
Oh, it's not like that. It's Rodofina.
Hold on a second. You're spelling your mother's first name?
Yeah. It's
Okay, spell.
Rodofina. Rodofina.
Did you get that pre-trial?
No.
I didn't get it neither, Judge.
Hey, Norris, can you
spell
put
that
it in the chat,
again?
please? Put it in the chat, please.
All right, it's
Hold on. The
I got it.
deputy's gonna help you put it in the chat.
He said Rodofina.
yeah.
That's correct.
All right.
You got it, Howard?
Yeah. So Rachel, tell us you need to bring a utility bill. 'Cause I don't know if the judge waiving it.
Waiving a utility bill?
utility
What is that
bill?
for?
For her to co-sign.
Proof of residence.
Oh, okay. All right. When I call her, I'll tell her.
Okay. I'm not gonna waive the utility bill.
Okay.
I'm gonna also add a curfew. And that curfew will be from 7 PM to 7 AM. So, Mr. Garcia, you need to be in the house, I guess, doing your homework from 7 PM to 7 AM.
All right.
Okay. And then when you get out of 7 AM, I guess you will go to school.
Judge, can you put in a caveat related to going down to report to probation? I'm sorry, to pretrial. Just because if he gets out of school at 3:30 to get from Sandy Springs to downtown report, it's going to be weekly. That's going to be pretty tight.
Pretrial.
I'm not saying, I'm not objecting to the curfew, Judge, but just for
Right.
purposes of reporting that one day a week or what have you.
Right.
You want him to
and-
report by phone weekly?
He can report by phone, I guess,
All right. Just
so that he won't have any reason to be out past 7 PM.
That's fine. That's great. Thank you, Judge.
Mm-hmm.
you got that, Melissa?
Are you good, Miss Grace?
Yes.
Okay. Any questions about the conditions or anything that I have missed?
You said 10,000?
Yes.
Not from us, Judge. Thank you.
Okay. Anything else from the state?
Nothing further.
All right. That is it, Mr. Garcia. No guns.
Okay.
Next, Your Honor, we have position number 5, Mr. Isaiah Glass.
Okay. This is 23 CR 001239E. Isaiah Glass, you're charged with 1 count of family violence battery. The offense date is February the 2nd, 2023.
Second arrest, 2021 suspended license. That's all I saw.
Okay.
Yes,
State.
this incident occurred on March the 2nd, 2023 at the Spanish Court Apartments, apartment number 9, and I believe that is 3225 Matador Court. In this incident, the victim is the defendant's sister, Miss Howard, and he is alleged to have choked her, causing visible lacerations to her neck, and a bruise on her left eye because he struck her as well. We were attempting to make contact with the victim in this case to do further investigation in relation to the alleged choking. However, we were not able to make contact. This was a verbal altercation that turned physical. Since they are related, we do have some concerns about the risk of reoffense in this case, and since it did just occur on March 2nd, we're not sure that there has been a decent cooling off period. For those reasons, Your Honor, and the violent nature of the offense alleged and the alleged injuries to the victim in this case, the state is going to be requesting a $3,500 surety, no further contact with the victim in this case, a stay away from the incident location, 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law.
All right, Ms. James.
Thank you, Judge. We're asking you to consider a signature bond in this case. Mr. Glass doesn't have significant criminal history. He has no violence. He just has that 1 charge. And Judge, just to point out in terms of this cooling down period point, I mean, this happened at noonish 2 days ago. So we would state that there has been time to cool down. The residence that this happened at, Judge, is actually Mr. Glass's residence. The lease is in his name and his brother's. And within this apartment are both of them, as well as his sister and her 2 children who are 3 and 4. I guess there's been some ongoing dispute about her living there. But outside of that, Judge, he does have another place to live if you're inclined to have some kind of stay away order. But again, the lease is actually in his name. He would have to evict her, I guess, if he wanted to have her leave the residence legally. But he is able to live with his girlfriend in Marietta. Outside of that, Judge, he does work. He's been working, doing billing work at Continuum Global Company for about the last 1.5 years. He works about 40 hours a week. He's got 1 child who is 9 years old that he helps to support, that is his child. And again, we're asking you to consider a signature bond in his case.
And the victim's first name for the record is Andrea, Andrea, last name Howard, common spelling. And again, Your Honor, just given that there are visible injuries alleged to this victim's neck and a eye, given that she was struck and choked, we think our recommendation is more than reasonable.
And Judge, if that were the circumstance, I'm pretty sure law enforcement would have sought out warrants to reflect that. Again, we're asking you to consider a signature bond in this case.
And he is 30 years old.
Yes.
How old are you, sir?
30.
And just for clarification, how old is the victim, his sister?
I don't have that, Judge.
Can you
How old's your
answer that,
sister,
Mr.
Mr. Glass?
22.
22.
And Your Honor, just to clarify, my apologies, the face of the warrant does in fact indicate that he choked and struck her, leaving those visible injuries.
All right, I am going to order a $3,500 signature bond through the jail. I'm going to order a stay away from 3225 Matador Court. It's like apartment 9. I do understand your name is on the lease, Mr. Glass, but right now I am going to still order you to go stay somewhere else while on bond. Because your sister is only 22 with 2 children, I'm going to put in the order, Ms. Grace, that you not proceed with any eviction processes against her at this time while on bond. Make sure that that does not happen. Now, if she chooses to move on her own, that's fine. And I understand it's your name and your brother's name on the lease, so I guess you all can work out about how you pay it, but even if you're not there, and I know that you're thinking of the responsibility because your name is on it, but we have a situation. I want to make sure that the victim will be safe and her children. I'm going to order no drugs, alcohol, or weapons while on bond. And I'm going to order a 1-day anger awareness course. And since you're working, you'll just have to find out where to take that. And the attorney can help you to find one to take an anger awareness course and pay for that. And I think that is it. Anything else from council?
Your Honor, I'd just like-
Judge, I have 2 things when you're ready.
I'd just like to clarify that I believe the apartment number is apartment 19, and I would
Oh,
just like to place the state's objection to a signature bond and a family violence battery on the record.
all right. Thank you. PD Jenks.
Judge, I just wanted to make sure that Mr. Glass was aware he could go back one time with law enforcement, Your Honor.
Okay.
And just so he can collect his things. Again, he stated that he can live in Marietta, but I'm a little unclear how, and again, with all due respect, Judge, how this court has authority to preclude him from any kind of eviction process. I'm not sure that they'd engage in that because it sounds like they actually have a pretty tight family, but considering he is legally on the lease and responsible for those rent payments to that apartment complex, and his brother is as well. If his obviously, if his brother, just thinking about all the permutations that are possible, if his brother sought to move forward on some kind of eviction process, I definitely wouldn't want that to be attributed to Mr. Glass. And then again, because they legally are actually on the lease and responsible for that property, I think they have legal remedies that they could move forward on if this was an ongoing issue, considering she is, again, just staying there and doesn't
Not
really
on
have
the
a legal
lease.
right to be there, correct, in terms of
Right.
the lease. So I would object to that condition, Judge, just because I don't really feel like it's practical and legal, just for the record.
All right. I will order the one-time police escort or law enforcement escort to go back to the property to get your items. And I will withdraw the condition of not pursuing eviction proceedings against the victim since she's not on the lease anyway.
Thank you, Judge.
So that will be my ruling.
Thank you.
All right. And no further contact. Did I say no further contact with Ms. Andrea Howard? I don't think I did. But no further contact with Ms. Howard, as well as staying away from that location, which is apartment 19. All right. That should conclude this case.
Thank you, Judge.
Next, Your Honor, we have position number 6 and position number 7, Mr. Aaron Gregory.
All right. This is 23 CR 001240G, Aaron Gregory, 1 count of battery family violence on 11/7/2022. And the second case is 23 CR 001241G, 1 count of battery family violence on January the 2nd, 2023. Are they the same victim state?
Yes, Your Honor, they are the same victim.
Okay, all right, we can read through both cases, take them together.
Okay, in the first instance.
Oh, I'm sorry, pretrial, I forgot, sorry.
It's 12th arrest. You got to open ag assault in Cobb County. 2022 failure to appear, 2015 obstruction, possession of marijuana. Those were convictions. And I think I saw a dormant bench warrant for battery DV in the cases.
You're
That's all
correct.
I got. That's it.
Okay.
To add
All
to
right.
that pretrial, we're saying there is a dormant bench warrant in case 21 CR 0051882G for battery family violence. That case is in fact against the same victim in our case today, where the defendant received a $4,500 good bond. And there was accrued to the children in the third charge as well. And one of the conditions was also no third party child contact. The victim in this case and the other case, as stated on the record, I was unable to verify who the victim was in that open aggravated assault on a Cobb. But the victim is Ambria Davis, AMBRIA.
Excuse me, Miss Duncan. I'm sorry, I can't hear you.
You can't hear me?
No.
What about now?
It's better for me. I don't know. Is that better for you, Miss Grace?
Can you hear me now?
Yes.
And can you repeat, would you mind repeating what you just said? Because I thought
Yes,
you
'cause I
said you
couldn't
didn't
hear
know who the
nothing.
victim was, but then it was an ag assault on a law enforcement officer. So I was confused. Would you mind just starting your narrative again?
Okay, so let me reiterate what I was saying. I wasn't able to get any information about the open aggravated assault out of Cobb County. However, this defendant does have an open battery family violence that's in dormant bench warrant status. That is case 21 CR 0051882G as in go. That is a battery family violence and cruelty to children in the third. This defendant did receive a $4,500 good bond, instructions to stay away from this particular victim and to have no third party child contact. And the defendant appears to also have another open case, but it is not related to this particular victim. The victim in this case and the open dormant bench warrant case is Ambria Davis. That's AMBRIA, last name Davis, common spelling. For the first instance that occurred on November 7th, 2022, it occurred at 1723 Evans Drive in Atlanta. That is the home of the defendant's uncle, I believe. There was, as alleged in the warrant, the victim noticed that her keys were missing, and she called the defendant regarding the keys, and he stated that he had taken the keys with him to his uncle's location, which is that location that is on the record. It is then stated that the victim and the defendant got into a verbal altercation that turned physical when the defendant in this case grabbed her around the neck and shoved her off the porch. She stated to officers he slapped her in the head and grabbed her violently by the arms, leaving visible markings on her arms as a result of this altercation. Officers arrived and they were able to identify the defendant based on his driver's license photo. For the second instance that occurred on January 2nd, 2023, a 911 call was placed by this victim reporting that her children's father, the defendant, had assaulted her. It's indicated that there was a verbal altercation that turned physical when he got angry and grabbed her arm and struck her, resulting in visible bruising on her left arm. As previously indicated, this defendant has already been under a no further contact order with this particular victim. Given that, Your Honor, and the continued pattern of violence, we do have concern about the risk of reoffense, given that there is an additional open battery violence case in cruelty to children. We're going to be requesting that had a $4,500 surety bond. We're going to be requesting a $5,000 cash only bond on both cases for a total of a $10,000 cash only bond, and no further contact with the victim in this case as previously ordered by the courts. And stay away from, I'm not sure which incident location is their home that they are alleged to have shared together. The second incident occurred at 1085 Catherwood Drive in Atlanta. So we're asking us a stay away from at least that address because we know the first one is his uncle's address. We're asking for no third-party child contact as previously ordered by the court, no alcohol, drugs, and weapons, no further violations of Georgia law, and an 8-week family violence class.
All right, Ms. Jenkins?
Thank you, Judge. Mr. Gregory is 26 years old. He tells me that actually he's able to live at his grandmother's house. So I think there's no problem in terms of him staying away from the uncle's location. That's where this did indeed allegedly happen. He does have a high school diploma. He works in the food industry, Judge, with a partner. They own a food truck that drives around Atlanta to sell their food. Judge, we're asking you to consider a $2,500 good bond in each case. We are objecting to the state's request of no third-party transfer in these cases. I did hear and understand there was a previous case with a cruelty to children, but I don't know the facts of that case, and I don't think that is relevant here since there's no allegation of that in these two cases. So we would ask that a third-party transfer would be allowed, or not be, that it would be allowed in these cases. Outside of that, Judge, nothing further.
And Your Honor,
Ms. James.
just to
Your
clarify,
client
Yes.
sent your client sent you a chat that he wants you to say to the judge.
and Your Honor, just to clarify,
Okay.
that order, that previous order did have a no third-party child contact. So if Your Honor was to order a third-party contact, it would be in violation of that previous order to have no third-party contact. Given these circumstances, while it is not necessarily including the child, we would like to make sure that there is some type of resolution to the continued pattern of violence that keeps occurring between these parties. As indicated, they do share a child or children. And at this point, these are 3 instances between these parties of battery family violence with visible injuries to our victim. And we were not able to reach her, and we believe our recommendation is reasonable out of an abundance of caution in the circumstances as alleged.
And Judge, just to let the court know, actually, Mr. Gregory is saying that the warrant from the January 2nd, 2023 incident is the same incident from the previous year. I only see in my paperwork, I only see a warrant. Wait, I could be wrong.
I have 2 separate.
So,
warrants, Your Honor.
yeah, I have 2 separate warrants. One is from, I do have 2 separate warrants. One says 11/7/2022 and the other one is January 3rd,
Correct.
2023.
And there are also different address incident locations.
So he was never picked up in 2022, is that correct?
I'm not,
Don't believe so.
but I believe that would be the
Well,
case.
I thought pretrial said a 2022 FTA, no? So did he FTA on that one? Or is that a different case altogether?
That's a
He's not-
different,
That's a different case?
that's a different case altogether.
Okay.
Yeah, my Odyssey isn't working, Judge, to be able to pull that up to see what the history was.
What was the question?
I think we answered it. The state did that 2022 FTA was a different charge altogether than these 2 battery family violence charges.
Because he also has another open felony case that's not related to these charges.
That's the open ag assault in Cobb.
There's also a 23 CP 216715. That's another case that I saw in Odyssey when I was doing my research on it. And if you give me one moment, I can tell you what that is.
Okay.
That is for driving, fleeing, or attempting to elude officers, felony in nature. That is for cruelty to children in the 2nd degree, felony in nature. Possession of Schedule 1 controlled substance, felony. Possession of a firearm or knife during the commission or attempt to commission, felony. Reckless driving, misdemeanor. Improper or erratic lane change, misdemeanor. And driving hit and run or failure to stop, misdemeanor. And that is open in Superior Court.
FTA is out of Cobb County from 2022.
Oh, that's Cobb. Okay. Thank you. All right, I'm going to order on the first case. This is the 2022, November 7th, 2022, with the Evans Drive address. I'm going to order a $20,000 surety bond on that case. I'm going to order a stay away from 1723 Evans Drive in Atlanta. I'm going to order once again, no further contact with the victim, Ambria Davis. Under any circumstances, stay away from her. No third-party contact, 200 yards away, all that will be in the bond order. I'm going to also continue with the no third-party transfer and no children, contact with the children or child that the parties share. To continue with the previous order, no third-party transfer of the child or no contact with that child. I'm going to order no drugs, alcohol, or weapons while on bond. And that will be for position number 6. And then for position number 7, which is January the 2nd, 2023, I'm going to order the $5,000 cash bond for that case. And stay away from 1085 Catherwood Drive in Atlanta. No drugs, alcohol, or weapons while on bond. And again, no third party transfer or contact with the child. I'll let you all deal with the DVIP later. But that's all I'm going to order for those 2 cases for now.
And just to clarify for the record, the second case has no further contact as well.
Yes. And again, no further contact with the victim as well, and the stay away, correct? All right, those will, that will conclude those 2 cases.
Thank you.
Okay.
Judge.
Next, Your Honor, we have Sequon Hardy, position number 8.
Okay. 23 CR 001237Y. Sequon Hardy, charged with 1 count of loitering and prowling, 2nd count of willful obstruction of a law enforcement officer, both with the offense date 3/3/2023. Pre-trial.
Yeah, first arrest.
Okay. All right, state.
Yes, this incident occurred at or near 680 Hamilton Avenue Southeast. Officers were dispatched to the location on a suspicious persons call. And Officer D. Padron was notified that there was an individual looking into a parked construction vehicle. It's indicated that when the defendant was confronted by a witness to the incident by the name of Mr. Arnold Lara about why he was looking into the vehicles, there wasn't anything said. However, when officers arrived and they were trying to talk to the defendant, given that he matched the description given by the original witness, he did not want to answer officers' questions. He began to walk away from officers when they were speaking to him about what was going on, and when he was initially placed under arrest. He resisted the verbal commands of those officers when they told him to stop, so that they could talk about what was going on. He took flight on foot, and he was later apprehended. And apparently there was another person, the leasing manager, who also pointed out that he had been there previously doing the same or similar types of actions, looking into those parked vehicles with his hands pressed near the window, trying to look and see what was inside. And that's why, in fact, they did call 911. Given and officers indicated in the warrant that this defendant had been arrested previously on August 23rd for burglary, entering auto, criminal trespass, and possession of a firearm. However, I don't see any disposition for that instance. Given this defendant's limited history, the state will be requesting a $1,000 total surety. That's $500 per count. And stay away from the incident location, no alcohol, drugs, and weapons, and no further violations of Georgia law.
Judge, it was juvie, that's why I didn't bring it up. So it's his first adult arrest though. But she is correct, those are the charges though.
Right, and as Your Honor knows, that juvenile history is relevant for the purposes of bond under OGCA 1511-703. Nothing further from the state.
All right. PD Jenks.
Thank you, Judge. We're asking for a signature bond in this case, Judge. This is, the warrant says it's 11 o'clock a.m. Near the belt line. What was interesting when I read this affidavit for arrest is that the officer was notified while at home in his house. And fast forward to this obstruction charges, my client says that the person that was chasing after him was in shorts and a t-shirt. So it may be that Officer Padron is law enforcement, but he wasn't dressed in any kind of uniform, which of course would be necessary to have an obstruction charge substantiated. But with that being said, again, Judge, I think the state mentioned multiple vehicles. That is not alleged in this arrest affidavit. It's alleged that he looked into a construction vehicle. At some time, it says that his arm is wrapped up because he indeed had an injury to his arm on that day. And we're asking for a signature bond in this case, Judge.
And to clarify, just briefly for the record, to clarify, the officer stated in the warrant that he did identify himself as an off-duty police officer and instructed the defendant at that time to stop. However, he didn't, and that was the basis for the obstruction. Nothing further.
I hear, and maybe I didn't, PD Jenks, what's the age and work history and of this defendant?
Yeah, I'm sorry, Judge. I kind of forgot to include that because I was really upset by the facts of this case. He's an 11th grade at Carver High School, Judge. He lives with his mom and his mother's boyfriend, brother, sister, and uncle. That was all I got from him. So you're 17, is that right, sir?
That's it.
Yes, he's 17.
I also work at the gathering spot on Northside Drive.
Sit back. That's it.
I also work at the gathering spot on Northside Drive.
Okay.
I couldn't hear what he said.
How many hours do you work at the gathering spot on Northside Drive?
Maybe 10 a day.
Okay.
And I'm sorry, Your Honor, I just want to make sure my recitation was clear. What I meant to say was that they indicated that.
Can't hear you a little bit.
Can you hear me now?
There. Let's see. Barely.
Okay. Can you hear me now?
That's better. I hope you don't have to stand up and shout, but yeah.
My computer is broken, so it's
having
issues. So there were different individuals that witnessed this defendant peering into those vehicles, and if the defendant is in school, this did occur in the morning, so that is kind of a strange time for him to be there if he was supposed to be in school, Your Honor. So we think the $500 per count is more than reasonable, nothing further.
And have you spoken to anyone, Ms. Jenks, on signing a bond for him, co-signing?
I haven't, Judge. Actually, I would need to get his mother's, let me see if it's on here. Actually, his mother's phone number is on here. So I would have to talk to her. Oh, I did get his mom's phone number from him, actually.
Okay. All right, I am going to order a $3,000 signature bond, $1,500 on each charge. And with that $3,000 signature bond, I'm going to order that through pretrial per judge. And I'm going to also order a curfew. Because Mr. Hardy, we don't want you getting in any more trouble. We want you to, number one, go to school at Carver or be in a program for a GED. So the first requirement is that you must go to school, preferably first go to school. And at 11 a.m. during the day, you should be at school. And if you're not at school, then you should be at home working on your GED. And you said you work about 10 hours at the gathering spot. So that's part-time, very little. I was going to have the curfew from 8 p.m. to 7 a.m. I'm not sure what time you do at school or what time you get in from working. If you work on a particular day, maybe you can't work or shouldn't be working if you aren't going to be a good citizen to follow laws. He raised his hand. I'm not sure. Maybe he's going to tell me about his times.
I work as soon as I get out of school.
Like at 3:30, 4 o'clock to what time?
10.
10 p.m.
Uh-huh.
Couple of days a week.
Yes, ma'am.
And do you have to have this job to help out, or?
I necessarily don't, but I just got one.
I'm indifferent. I would like for you to work and have some income. So I tell you what I'm going to do is on the days that you're working, which means once again, you're just going to be coming from the gathering spot to your house. On the days that you work, 2 or 3 days a week, I will allow you to be out. I guess, can you make it home by 11 p.m.?
Yes, ma'am.
Okay. So the days you work, you can be out till 11 p.m. And that should not be 5 days a week. It should be 2 to 3 days a week. So don't increase your hours just to increase your curfew.
Yes, ma'am.
All right. And the days that you're not working, the other 2 to 3 days, you should be in by 8 p.m. And getting out in the morning at 7 a.m., does that allow you time to get to school?
Yes.
Okay. All right. And then you will report to pretrial once a week by phone.
Okay.
So we'll keep up with you. No drugs, no alcohol, no weapons of any type in your possession. Shouldn't be around any weapons while you're on bond. I'm going to order a stay away from that 680 Hamilton Avenue Southeast. Should not go to that location.
Supposed to co-sign this?
His mother, and we need her name. What is your mom's name?
Sharon Hardy.
Sharon Hardy. Okay.
Tell her make sure she
And
got
she
a
needs
valid
to,
ID.
right, she needs a
Okay.
valid ID and a utility bill from her residence, from the residence.
Okay. Judge,
Okay.
can you give me the curfew times again when he's at work? I have the ones for when he's not at work.
When he's at work, he should be home. He said he can be home by 11 p.m.
So from 11 p.m. to 7 a.m.?
Yes, ma'am. That's correct.
And they do curfew checks too, just so you know.
All right, let you know, they will do curfew checks. And doesn't mean you're on a cell phone somewhere down the street. You gotta be at home. And they have a way to check that.
Thank you.
All right,
Judge.
good luck to you. All right,
This per judge?
per judge, yes.
Next, y'all, you have position number 10, Mr. Casey Jenkins.
This is 23 CR 001203H. Casey Jenkins charged with 1 count of criminal trespass, offense date March 2nd, 2023. Free trial?
I don't have that file. I thought that was loaned out to Grady, so I didn't pull it.
Oh,
Yeah, we didn't know that he was going to be included on today's calendar. I did speak to him,
is this
Judge.
the one that we reset? No, from yesterday, I think?
I
No?
believe so,
We
Judge.
did, okay.
Yes.
So he is back. State, are you prepared to go forward?
Yes, Your Honor.
Okay. Can you give us the history that you have, please?
Yes, I have 2 total arrests, 2 and a 1996 conviction for pandering by compulsion.
Okay.
Yes, Your Honor. This incident happened March the 2nd, 2023, at 55 Lower Wall Street in Atlanta. And it's where officers, including the Georgia Capitol Police, asked the defendant to leave the premises several times, yet the defendant refused to leave. And for this reason, we're asking for an $1,000 surety bond and a stay away order at the 55 Lower Wall Street address. That's all from the state.
And how are you spelling Lower Walsh?
Lower is Lower, Wall, WALL.
Oh, okay. All right. PD Jenks.
Thanks, Judge. I think, did I hear the state correctly that there's only 1 prior from the 90s?
Yes, that's correct. That's
Okay,
right.
Judge, we're asking for a signature bond through the jail. Mr. Jenkins is 52 years old. He did complete high school, 12th grade, and we're asking for a signature bond in his case.
All right, I will grant a $2,000 signature bond through the jail. There will be no drugs, alcohol, or weapons while on bond. And you're to stay away from the 55 Lower Wall or Lower Wall Street, which is at the Capitol, I understand. So where this incident occurred, Mr. Jenkins, you to stay away from that incident. And no drugs, alcohol, or weapons while on bond. All right.
Thank you, Judge.
Mhm.
I'm sorry, did we skip position 3, John Davis? Or did I not write
Well,
down?
Ms. James, he was giving me issues inside the court, so I'm gonna put him last.
Okay.
He kept trying to hit on the females in the courtroom.
Okay.
Yeah, I put that out there. I'm sorry, Ms. James. Your Honor, what was that bond amount for position number 10?
$2,000 signature bond through the jail.
Thank you.
Huh?
Okay. Next, we have position number 11, Mr. Kemp.
right. This is 23 CR 0012229Y. Jonathan Kemp, you're charged with 1 count of simple battery. Offense date is March 3rd, 2023, pretrial.
Kemp, 25 total. I'm gonna keep this one brief. He got an open theft by taking. It's a 12 SC case, 12 SC 114286. Not sure why it still shows open. I guess it is, maybe. Theft by taking, ag assault with intent to rob, possession of a firearm during the commission, possession of a firearm by convicted felon. On probation for ag assault with a deadly weapon, possession by a convicted felon, 19 SC 171059. March 2021, they gave him 2 years to serve, 13 years. Probation for the ag assault and 8 years probation for possession by a convicted felon. That's it.
All right, State.
Yes, Your Honor, this incident happened yesterday at 1133 Arlington Avenue Southwest. And this is where officers responded to a dispute where I'm sorry if I mispronounced the victim's name. Her name is Keyrina, and that's spelled Keyrina Jackson, where Ms. Keyrina Jackson stated that the defendant was under the influence of alcohol and became irate. And during this encounter, Ms. Jackson explained that the defendant began screaming at her and getting in her face to intimidate her, and he started throwing her clothes out of the room. And eventually the defendant then put his hands around Ms. Jackson's neck in an attempt to strangle her. And Ms. Jackson told the officers that she cut the defendant with a box cutter in an effort to get a loose from him from trying to strangle her. The defendant did tell officers that she was in fact afraid of the defendant. Our victim advocate reached out to her, but we were unable to get a hold of her for today. And for these reasons, Your Honor, we're asking for a $3,500 signature bond. Not signature bond, I'm sorry, a $3,500 surety bond. We're asking for no further contact with Ms. Jackson. We're asking for a stay away order at the address of 1113 Arlington Avenue. We're also asking for a 1-day anger awareness course.
All
And
right.
no drugs, and we're also asking for no drugs, alcohol, or weapons while on bond.
All right. PD Judd.
Yes, Your Honor. Attorney Judd, excuse me, for Jonathan Kemp. Your Honor, just for the record, Mr. Kemp does not qualify for our representation, so we are only representing him today for the purposes of bond. Your Honor, he is 44 years old. He has lived in Georgia his entire life. He attended Alonzo Krim High School in Atlanta. His entire family is here in Georgia. 4 children, a 23-year-old boy, 20-year-old girl, 15-year-old girl, and 13-year-old boy, for whom he does provide financial support. Your Honor, he does volunteer work for Habitat and Habitat for Humanity, and he is currently employed with CSK Plastic. It's here in Atlanta. He's done that for about a month after coming from Big Dave Cheesesteak in Doraville, where he had that job for 1.5 years. Your Honor, he is okay with a no further contact with the complaining witness. However, he would have issue with a stay away order, as that instant is his location. The complaining witness does not stay at that location, which was part of the issue, Your Honor. Mr. Kemp does deny the allegations against him. He was simply telling the complaining witness that she was no longer welcome in his house when she came at him with a box cutter. He is the one who has slashes on his body and a torn open shirt, Your Honor. If there was any contact made with the complaining witness, and we're not saying that there was, but in arguendo, it would have been in self-defense. So, Your Honor, he is the one that was attacked. We are asking for a signature bond in this case so that we can further investigate this case and find out the truth of what happened.
Yes, Your Honor, I would just like to reiterate or just bring forth that officers did arrest the defendant in this case, and because they saw him as the aggressor in this case. In the warrant, it does allege that Miss Jackson cut the defendant in an effort to get him off of her.
And if I may respond, Your Honor, between the two, there was only one person who used a deadly weapon, and it did happen at the defendant's house.
All right. Given the defendant's history, I'm going to order the $3,500 surety bond. I'm going to order no further contact with the victim, Karina Jackson. No drugs, alcohol, or weapons while on bond. And I am torn with the stay away. And what I usually order is that the defendant will return with a law enforcement escort. And if they can determine after looking through the residence that there are obviously no female clothes from the victim, or that she does not reside there, then he can stay there. If it appears that she has belongings there and, obviously clothes, shoes, and a toothbrush from a female, then he cannot reside there. And I know that can be slightly confusing, but that's the only way I know to do it without ordering him not to return to his home. And I know he's trying to say something anxiously. Don't know, Mr. Kemp, if your attorney is going to want you to speak.
I usually recommend that my clients don't speak and allow me to speak for them. I obviously cannot stop him from speaking.
All right. Is there something you're going to tell me about the living arrangements, Mr. Kemp? It should be very limited and short.
Yes, ma'am. Let me tell you this, Judge. I did not attack her, Judge.
I don't want to hear about the facts of the incident. I just want to hear about the living arrangements there.
I'm sorry, Your Honor. I live there, Your Honor. I brought her. She stayed with me. She stayed there with me for 2 months. And she got living with me. She got mad at me.
Okay, whose name is on the lease there? Is it a lease or a purchase?
Mine, sir. Mine, ma'am. It's a rooming house, ma'am.
It's a rooming house.
Yes,
So
ma'am.
you rent a room there?
Yes, ma'am. I've been there for 6 months, ma'am.
Okay, and she does not rent a room there?
No, ma'am. No,
Okay.
ma'am. I was trying to help her, ma'am.
Okay.
And
Well,
I-
I'm a little clearer if it's a rooming house and you have a room that you rent there.
Yes, ma'am.
And so unless the state has any huge objections to it, I won't necessarily order you to go back there with law enforcement, but you just stay away from her. So I'm going to remove that condition because it's a rooming house. But if you go back there and you see her, you need to leave and go the other way because you'd have no further contact with her. So don't want you to get rearrested. You go back there, she's there, and you all get into an altercation again. So you're going to have to be careful because you have a condition of no further contact with her. You stay 200 yards from her, can't contact her at all by any means, and you can't be around her. So you need to be careful if you go back there and she's there.
Yes, ma'am. She moved to the care anyway, ma'am.
Okay, well, good. Then you should be fined on bond, staying away from her, and no further contact with her. And I won't do a stay away from that location since it is a rooming house. Okay.
Yes,
Thank
ma'am.
you, Your Honor.
All right. Good luck to you.
Next, Your Honor, we have position number 12, Mr. Mathis, Raphael Mathis.
This is 23 CR 001230C. Raphael Mathis, you're charged with 1 count of battery, family violence. The offense date is June 1st, 2022. Pre-trial?
Yeah, 14 total.
Okay.
2015 misdemeanor possession of marijuana, that was dismissed after conditional discharge. 2019 battery DV, criminal trespass. He got first offender for the battery DV. It was a simple battery with that arrest, but it was dismissed. 2019 obstruction, disorderly conduct. They were accused and they were dismissed out of Henry County. 2020 probation, disorderly conduct. 2021 criminal trespass, 2 counts. January 2022 battery arrest out of Cobb. January 2023 Clayton County misdemeanor possession of marijuana. February arrest out of Cobb failed to appear, and then it's this arrest. Hold on. 2020 out of Tennessee, conspiracy to commit robbery, conspiracy to commit aggravated kidnapping, conspiracy to commit aggravated burglary. 2020 fugitive from justice. 2022 theft of property, 3, 4, 5 counts. And let's see, history out of Kentucky. 2019 criminal possession of a forged instrument, 2, 3, 4, 5, 6, 7. He got a lot of counts though. What else? I think it's one more. Yeah, and the 2020 failed to appear out of Lexington. That's it.
All right. State?
Yes, Your Honor, this incident happened 8/1/2022 at 2113 DeFors, that's DEFOORS, Ferry Road, Unit D8. And this is where officers responded to a dispute that the defendant and Miss Jasmine Wellesley, Wellesley is WESLEY. She was at the location with a U-Haul truck with the intent to move her things out. And the defendant arrived to the location and they began arguing. And during this argument, the defendant began to throw Miss Wellesley's clothes over the banister. And then he grabbed Miss Wellesley and he grabbed her by the collar and threatened to throw her over the banister. And then the defendant hit her in the face, causing visible injuries to her neck and face. And so, Your Honor, the state is asking for a $3,000 surety bond. We're also asking for no further violent contact with Miss Wellesley. We're asking for no alcohol, drugs, or weapons in a one-day anger management course. We were able to speak with Miss Wellesley, and I believe she might be on the Zoom call. So if she is, I would like to sound for her.
Is Miss Jasmine Wellesley here? I see a Tangi, but I don't think I see a Jasmine Wellesley.
She might not be on. She spoke with our victim advocate, and she said that she would try to get on, but she might not be on.
Okay. And she said, and you asked for, requested no further violent contact?
Yes, because this incident happened last year, and the defendant and Miss Wellesley are expecting a child, and they're currently living together. This is what she told our victim advocate. So I think the cooling off period has taken place with them.
Okay. All right. PD Judd.
Yes, Your Honor, Attorney Judd for Raphael Mathis. Mr. Mathis is 26 years old. He's lived in Georgia his entire life. He is a graduate of South Cobb High School. His whole family is here in Georgia, and in fact, currently lives with his mother and grandmother. So he has strong ties to the community and strong reasons to stay here and to keep him accountable to the court. Your Honor, he does regularly help volunteer coach for football and basketball in DeKalb. He does admit that he has the FTA out of Cobb, which he did take care of immediately, Your Honor. He's not currently on probation or parole. And Your Honor, he has no issue with a no further violent contact. It's my understanding that he no longer lives at that location, nor does he live with the complaining witness. So, Your Honor, we are asking that he be considered for a signature bond since he currently is, sorry, let me get to his job history. He's currently not able to work. He is looking for work as we speak, but has not been able to find anything as of yet. So any sort of good bond or surety bond would be tantamount to forcing him to stay in jail.
Okay. I'm going to, and I guess the biggest issue here is the fact that it occurred June of 2022, and the parties, I'm assuming, are still together without incident, but I do have some concerns about that prior incident. I'm going to order the $3,000 surety bond. I'm going to order no drugs, alcohol, or weapons while on bond. I'll order the no further violent contact with the victim, Jasmine Wellesley. And that's all I order for this time. I guess I won't do the stay away.
Your Honor, we're also asking for a day anger awareness course, a 1-day anger course.
I'm not for sure if he can pay for it if he's not working.
Yes.
I try not to order it if they're not working.
Yes.
So that doesn't bring them right back for that violation. I'll hold off on that for now. And you said he didn't reside at this DeForest Ferry or does not reside there any longer?
Not any longer, Your Honor. He now has a address over in Argus Circle.
All right. I guess that'll be it then.
Thank you, Your Honor.
Mhm.
Next, Your Honor, we have position number 15, Mr. Nathan Stallings.
This is 23 CR 001232C. Charged with two counts of terroristic threats. The offense date is May the 4th, 2021. Pre-trial.
Second arrest, 2016, suspended license conviction. That's all I saw.
Okay. Right.
Yes, Your Honor, this incident happened 5/7/21 at 1100 Hammond Drive, Suite 500. And Your Honor, excuse my language in this, but the defendant, there are two victims in this case, Mr. Royston Blackman and Miss Rashonda Wright. Mr. Blackman is the defendant's or was the defendant's co-worker at the time, and Miss Rashonda Wright was the defendant's manager at the time at Walgreens. And the defendant told Mr. Blackman that he was going to kick his ass, and then the defendant told Miss Wright that he was going to have someone fuck her up. And so for these reasons, Your Honor, our victim advocate was able to talk to both of the parties, the victims. They both said that they have not seen or talked to the defendant since this incident happened, and they declined to come on the Zoom court today, Your Honor. The state is asking for a $1,000 surety bond and a stay away order from no further contact for both Mr. Blackman and Ms. Wright, and a stay away from the incident location of 1100 Hammond Drive, Suite 500. That's all from the state.
And is that a breakdown of 500 on each?
Yes, it is, Your Honor.
Okay. All right, PD Jet.
Your Honor, Mr. Nathan Stallings is 25 years old. He's lived in Georgia for the past 6 years. He currently lives with both his mother and his sister. He has strong ties to the community and a support system to get him through this process. I'm sorry, Your Honor. He has no similar priors, as we heard from pre-trial. His only prior charge was an expired license or suspended license charge, some form of document charge, Your Honor. So no felonies, no violent or sexual crimes. Your Honor, he has been working with Top Golf for the past 6 months here in Atlanta over in Midtown. He regularly donates through food and clothes drives at work. He has no FTAs that we're aware of, no probation or parole. He does know the complaining witnesses, but has not spoken to them since the incident. So he has no problem with a no further contact with either of them or a stay away from the incident location. Your Honor, Mr. Stallings does vehemently protest any of the allegations here. He never threatened his managers, who these people were to him. He may have used some colorful language, saying something along the lines of "screw this job," maybe more colorful than I would want to speak out in court, but nothing towards either of the people individually. Simply saying that the dissatisfaction with his job, Your Honor. And he does want to emphasize that he was raised by a single mother, and due to that, he doesn't threaten women. Your Honor, if his single mom is anything like mine, he should be more afraid of what his mom would do than this court if any of this were true. So, Your Honor, we are asking that he be considered for a signature bond.
Your Honor, I would just like to say that we spoke to both of the victims, specifically Miss Rashonda Wright today. Our victim advocate spoke with her, and she did in fact confirm that the defendant did say that to her on that day.
Okay. Well, I hope he is certainly more afraid of his mom and would not do that, but that's for another date and time. This is a bond hearing. This did happen over 2 years ago, almost 2 years ago. And so sounds like he's working again somewhere else, and I hope being a productive citizen. So I'm going to order a $2,000 signature bond through the jail. That's $1,000 on each of the charges. I'm going to order a stay away from the Walgreens at 1100 Hammond Drive, Suite 500. Stay away from there. Going to order no further contact with the victims, Royce Blackman and Rashonda Wright. Stay away from them. If you go anywhere and see them, go the other direction. I'm going to order no drugs, alcohol, or weapons while on bond. And I think that will be it. Anything else from counsel?
No, Your Honor. Thank you.
All right.
All right, thank you, Your Honor. Y'all have a great afternoon. Thank you, guys.
All right. Good luck to you.
Next, Your Honor, we got position number 3, Mr. John Davis. Put your mask on.
This is case number 23 CR 001234D. They're charged with 1 count of lauder prowling, 2nd count of criminal trespass, and a 3rd count of theft by taking, all with the offense date of March 3rd, 2023. Pre-trial?
Yeah, 27 total. Just hold on real quick. He got a case 18 SC 156655, burglary 2nd degree. In June 2018, they gave him a 5-year sentence, 1 year to serve, 4 years probation. So that should time out in June. I got a theft by shoplifting out of state court. They gave him 12 months probation for that in December of last year. I got 2017 criminal trespass, another 2017 trespass. It was reduced to DC time served. That's the 2017 burglary. 2020 probation. 2021 given false name conviction. 2022 trespass. 2022 probation. Another 2022 and another one for trespass. Theft by taking 2022. 2022 failure to appear given false name. 2013, he was arrested in Indiana. It just says a warrant. That's all. What else? 2006 Kentucky shoplifting. 2009 trespass. 2009 bench warrant. 2011 bench warrant. 2012 burglary. Criminal mischief 3rd degree. 2013 parole violation. 2020 public intoxication, 2020 failure to appear. That's it.
All right, State.
Yes, Your Honor. This offense did occur yesterday at the Atlanta America's Mart located at 240 Peachtree Street Northwest in Atlanta. The defendant was on site at the location of the Atlanta America's Mart and was noticed by the security officer and detained for going into the coat check office and stealing the purse of Leslie Cortez. Eventually, they were able to recover that item. But he had previously been given a criminal trespass warning by security officers on January 12, 2023, and had given them a false name at that time. However, they were able to provide officers with a photo of him with that previous warning. So that is the basis for our criminal trespass and the fact that he was in the coat check clerk's office without permission and taking that purse. Your Honor, State does have concern about the risk of offense. As pre-trial stated, this defendant does have some recent convictions for theft offenses, as well as several criminal trespass convictions, at least 3 on my count in 2022 alone. We do have some concern about flight risk. This defendant does have failure to appear in his history, not only from Georgia, but he also has them out of the state of Kentucky as well. Given the facts and circumstances and the all the factors present in this case, Your Honor, we're going to be requesting a total $3,500 surety. That's $1,000 on the Lord Prowl, $1,000 on the criminal trespass, and $1,500 on the theft by taking. No further contact with Ms. Leslie Cortez or any of the employees of the Atlanta America's Mart, to stay away from the Atlanta America's Mart, as he was previously told, and no alcohol, drugs, and weapons, and no further violations of Georgia law.
All right, PD Jenks.
Judge, we're asking you to allow a $500 good bond on each charge. I don't think the state has to worry about him being a flight risk. Currently, he is homeless. He stated to me that he's trying to get back on his feet. That's all we've got. Thanks.
Okay. Is your social services going to be able to possibly see him to provide any assistance for housing?
I mean, we can ask one of our social workers to see him and see if there are any options in terms of that. I know that many people are on waiting lists, you know, in various categories. But we can definitely make that referral, Judge.
Okay. I'm going to order a let's see, hold on 1 second. I'm going to order a $2,000 surety bond. That will be $500 on the Lauder prowling, $500 on the criminal trespass, and $1,000 on the theft by taking, for a total of $2,000 surety bond. I'm going to order a stay away from 240 Peachtree Street Northwest, the America's Mart. I'm going to order no further contact with the victim, Leslie Cortez, or any of the employees of the Atlanta America's Mart, and no drugs, alcohol, or weapons while on bond. And that should be all for the ruling.
Judge.
You gotta take a bond. Next, we have position number 14, Mr. Keelan Smith.
This is 23 CR 001231G. Charge of 1 count of simple battery, offense date March 2nd, 2023, pretrial.
Smith. This is ninth arrest, 2022 criminal trespass, 2019 probation, 2018 parole violation, 2013 burglary conviction, 2012 theft by receiving conviction. Based on the math, let's see. The burglary first degree was out of Lamar County. 2014, they gave him 5 years to serve, 5 years probation. So that should end next year. And got the open trespass in state court, 22 CR 004 775G. That's it.
All right, state.
Yes, Your Honor. So this incident happened on March the 2nd, 2023 at 30 Alabama Street, Atlanta, Georgia. And this is where MARTA officers responded to I'm sorry if I mispronounced the name, Tanika Currington. Tanika spelled TANGENIKA, Currington, CURRINGTON. And Ms. Currington explained that she was physically assaulted by the defendant, and MARTA camera showed that the defendant did strike her in the face with his forearm. And the defendant and Ms. Currington were in a relationship, but Ms. Currington did speak with our victim advocate. She told her that they are no longer in a relationship and that she is afraid of him. Ms. Currington also let our victim advocate know that this is the second time that he's hit her, but this is just the first time that she's called the police. I would like to sound for Ms. Currington if she's on the line. She did let us know that she was hoping to hop on today on the Zoom.
All right. Ms. Tangika Carrington.
Hello.
Tangi?
It's Tanjanika.
Tanjanika. If you want to address the court today, I have to see your face and you turn on your camera.
Okay, okay, 1 second. Let me turn the camera on. Hello, I was coming from work. I'm sorry.
Okay, hold on a second. What's the 30 Alabama Street? That's what kind of
5
location?
Points.
5 Points MARTA station?
Yes.
Okay. That's what I was thinking, and that's what I was asking. But hold on 1 second. If you're willing to address the court today and allow you to do that, I need to swear you in.
Okay.
I'm kind of concerned. Are you at work right now?
No, I just got off from work.
Okay. All right. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. Put your hand down. And are you in fear of Mr. Keelan Smith?
I had told you.
I'm
I
sorry?
told them that it was caught off guard. I'm usually not. I only get scared because we have an anger issue. But on a typical day, no, Mr. Keelan has never really struck. This is the second time it caught me off guard because he would hit things like objects and slam the door and walk out. But this is like the second time that this happened off guard. And though both times he was off his medication because from the understanding, his sister called on that Thursday. His sister called the police for me, and she told me it was that she called, and I just responded to the call that she was there with me while the police came on scene with her brother, and she said she wanted to make the call. I had to go forth with the charges.
Okay. Are you residing with him?
As I'm residing?
You all live together?
No, that's another thing. I had to do another police report because I did allow.
That's a lot of background noise. I can't hear you.
I'm sorry. I had another police report coming because I had to take another police report out because Mr. Keelan did not. He had spent the night at my old apartment, and they said he left trash everywhere, vandalized the place. And so I wouldn't get charged for it. I had to put a police report out for him, but we don't stay together.
Okay, and you don't have any children together?
No, we does not have any kids together.
Okay, all right. And so you still want to have contact with him?
Like I told him, I don't have no fear of him. I just want him to get better. I'm just asking him to get better, and we can go separate ways or be cordial to, if that's what he wants. But I just want to do my police report for the vandalism of the house, though. But they explained I have to go to DeKalb County.
Okay. All right, any cross-examination, State?
No, Your Honor, no cross-examination.
Any cross-examination, Mr. Judd?
No, Your Honor.
All right.
Your Honor, I don't believe I did. I don't think I did the state's recommendation on this case.
I was going to say, I thought about it. I said, I don't think she was quite finished, so I apologize for interrupting. Miss Sherrington, can you mute yourself now, please? It's a lot of background noise. Thank you. All right, go ahead,
Yes.
ASG Bickerstaff.
Thank you, Your Honor. The state is recommending a $3,000 surety bond. We're also recommending a no further contact order with Ms. Currington. We're also recommending a 1-day anger awareness course and no alcohol, drugs, or weapons while on bond.
All right. All right. PD Judd.
Your Honor, Mr. Smith is 30 years old. He's lived in Georgia his entire life. He attended North Clayton High School and ultimately graduated from Mount Zion High School. And he also attended Atlanta Technical College. He has strong ties to this community. Most of his family is here in Georgia. He's actually been speaking with some family, and he may be able to stay with them going forward. As of right now, though, I'm sorry, Your Honor. As of right now, though, his mailing address is 420 Cortlands. He's currently homeless, and he is not working. While he is looking for a job actively, in fact, has had several good interviews in the past couple of weeks, he currently is not working and would not be able to afford any form of surety bond or any kind of classes, Your Honor. Your Honor, it's my understanding that there's no similar violent crimes, and after hearing pretrial read through his history, I don't believe I heard any crimes of violence. He does regularly work with nonprofit organizations such as Georgia Equality, which works with AIDS and HIV communities, and Urban League of Atlanta, which helps with voter awareness. I didn't hear pretrial mention FTAs. I could have misheard, but Mr. Smith is unaware of any FTAs. Your Honor, he is aware that he's currently on probation. That probation is actually over this year, and he has been keeping up with that. He's completely fine with a no further violent contact or even a no further contact, Your Honor, with the complaining witness. We would take issue with any sort of stay away order, since he is not working and thus does not have any money to have a car or drive. He does need MARTA to be able to get around to his appointments and to his interviews, and to his hospital and all of that stuff, Your Honor. So we would be asking that he be considered for a signature bond. Furthermore, Mr. Smith does maintain that he was the one being harassed. He simply tried to create some space from Ms. Smith, and if there was contact, then it was either accidental or it was in order to try and create space because he was afraid of Ms. Smith.
Okay.
Mr. Smith, I'm going to ask that you actually don't speak unless it's something critical that you feel I've missed. I can't stop you from speaking, but I would recommend that you don't.
He's muted, Deputy, but I'm not sure what it is. Is he trying to correct some information?
I do not wish to correct any information. Everything that was said prior to me speaking has been pretty much correct, but for the most part, I just want to bring to the court's attention also that I have severe trauma for the last year and severe pain that I've been dealing with for years now. On a personal note, I have on my own tried to venture out for anger management classes down at 10 Park Place, and I am currently active in trying to change my life from my past arrest and my past history.
Okay. All right, thank you for that. This incident occurred at the 5 Points MARTA, is that correct?
That's correct, Your Honor.
Okay. I'm going to order a
Can I say something?
very briefly.
Miss, I have never, ever harassed Mr. Smith. If anything,
Okay,
Mr.
well, you're
Smith.
not being charged here. I don't want to go into the facts of that.
No, I know. I'm just saying I always been a good help, and I never said he was bad. I just said to your person that reached out to me that if we can have a no violent contact, that was okay, because I always been there and helping Mr. Smith, but I have never harassed him or been violent towards him.
All right, that's fine. I'm weighing some issues here about bond and whether he's going to show back up for court and all of those things. And I understand he's on probation, but he's been keeping up with that. And I understand that the victim is not in fear of him. And that's what I want to make sure of, that the victim will be safe based on the bond that I give and any type of conditions to ensure the victim's safety as well. I'm going to order a $4,000 signature bond through the jail. I'm going to order no further violent contact with Tanika Currington. I'm going to order no drugs, alcohol, or weapons while on bond. And I know with the state's recommendation, you were asking for him to have a stay away from the 5 Points MARTA, is that correct?
No, Your Honor, I'm not asking for a stay away from the 5 points.
Okay.
Yeah.
All right, well, good. I was not going to order that at this time. But be careful, Mr. Smith, in your interactions and you're on public transportation or on MARTA, because that could eventually get you banned from using that if you have other incidents on MARTA or public transportation, okay? So let's see how you do with this. No further violent contact with Ms. Currington. No drugs, alcohol, or weapons while on bond, except for any medication that is prescribed to you. All right.
Thank you.
And that should be it. Okay.
Judge, what was the bond amount again?
$4,000 signature bond through the jail.
Thank you.
Mhm.
Thank you.
All right.
Next, we have position number 16, Mr. James West.
Okay.
Last case.
Yes.
Yes.
All right. This is 23 CR 001233H. To charge of 1 count of battery and a 2nd count of driving, possession of open alcohol container, both with the offense date March 3rd, 2023. Pre-trial.
This is 8th arrest. Last arrest was 06, carrying concealed weapon. Possession of marijuana dismissed.
All right, state.
Yes, Your Honor. This incident happened yesterday, March the 3rd, 2023, at or about 879 Neal Street, Northwest Atlanta. And this is where officers responded to a call from Miss Tiffany Thomas, where she first ran to just a stranger, a citizen, Mr. Anthony Pless's vehicle. And then she ran toward an officer's vehicle, telling them that the defendant had just attacked her and she was trying to get away from him. And so Ms. Thomas explained to the officers that earlier that day that the defendant continually tried to force her to have sex with him, and she continually told him no, and that the defendant then kicked and punched Ms. Thomas, causing a knot on the right side of her head. And she also told officers that that attack caused pain on the right side of her ribs. When officers approached the defendant in his vehicle at the scene, the defendant told the officers that he had loaned Miss Thomas $40, and that a couple months ago, he was just simply trying to get his money back. And that Miss Thomas, in fact, had attacked him. However, a neighboring resident, her name is Miss Carolyn Jones, her Ring camera captured what happened, and she allowed officers to look at it. And that Ring camera footage showed that the defendant was kicking and punching, essentially attacking Miss Thomas. And the footage also had audio of the defendant threatening Miss Thomas to have sex with him, and threatening her that if she didn't, that he was going to hurt her. And the footage, nowhere in the footage did the officers hear where the defendant was trying to get money back from Miss Thomas. And officers also, Your Honor, when the officers approached the defendant and asked him to step out of the vehicle, they did find open alcoholic beverage under his driver's seat. And so, Your Honor, the defendant, not the defendant, Your Honor, Ms. Thomas told officers that she was very afraid in that moment, and that's shown or evidenced by her running to officers when they arrived to the scene. And for these reasons, Your Honor, we're asking for a $35,000 surety bond, $3,000 on the battery, $500 on the open container. We're asking for no further contact with Ms. Thomas. We're also asking for a stay away order from that location area, 879 Neal Street. And we're asking that there be no drugs, alcohol, or weapons while on bond.
And
And
so
we're
you
also
3,500, not 35,000. 35.
Yes, I meant 3,500. I'm sorry, Your Honor. And we're also asking for a 6-week anger management course.
All right. PD Judd.
Your Honor, Mr. West is 45 years old. He's lived in Georgia his entire life. He attended McNair Senior High School in Decatur. He then went on to receive his GED and then attended West Georgia for a time as well. Your Honor, his entire family is also here in Georgia, as well as his 20-year-old daughter, for whom he still provides monetary support. So, Your Honor, he has very strong ties to Georgia and reasons to stay in the area. It's my understanding that he doesn't have any similar priors of this kind, no prior felonies from what I've heard or from what I've learned from Mr. West, no violent or sexual crimes in the past. And he is stably employed with UPS as a driver. He's had that job for approximately 3 years, and he regularly volunteers and helps with food pantries. Your Honor, he is not currently on probation or parole. It's my understanding he doesn't have any failure to appears. I may have missed that if pretrial said that he did, but I didn't hear any. And while he does know the complaining witness as a friend of the family, he has stated that he has no problem with a no further contact order, no problem with a stay away from the location order. But Your Honor, if you were to look at Mr. West, he seems to have his shirt in tatters. He has visible scratches on him. He does maintain that he is the one that was attacked. Any contact that was made with the complaining witness was purely in self-defense. That the complaining witness then in the middle of him defending himself, went to go push the Ring camera in order to activate the camera, essentially staging the issue. He is the one who extricated himself from the situation by getting in his car and leaving. So we do ask that Mr. West be considered for a signature bond while we look into these allegations.
Your Honor, I just want to put on the record that our victim advocate did reach out to Ms. Thomas, but we were unable to get in contact with her. And just to reiterate that the warrant alleges that the Ring camera footage shows that the defendant was kicking and punching Ms. Thomas, Your Honor. Thank you.
Okay. Okay. I'm going to order the $3,500 surety bond. That's $3,000 on the battery and $500 on the driving open container. And with that $3,500 surety bond, I'm going to order stay away from the 879 Neal Street Northwest. I'm going to order no further contact with the victim, Tiffany Thomas. No drugs, alcohol, or weapons while on bond. And that's all I'll order at this time.
Yes, Your Honor. And for
All
the
right.
record, Mr. West does not qualify for our services after the purposes of bond.
Okay. All right. That'll conclude this case.
Thank you, Your Honor.
Thank you. I think I'm making sure we've got them all.
Yeah, I don't have no more files.
All right. That is it. We'll do a reconciliation real quick with Miss Grace. Well, would you like to stay with us, Mr. Howard, or you're leaving us?
I'm listening.
Are you listening? Okay.
Okay, position number 1 is a $4,500 pretrial bond per judge. Position number 2 is a $2,000 pretrial bond. Position number 3 is a $2,000 good bond. Position number 4 is a $10,000 pretrial bond. Position number 5 is a $3,500 sign-on bond through jail. Position number 6 is a $20,000 good bond. Position number 7 is a $5,000 cash bond. Position number 8 is a $3,000 pretrial bond per judge. Position number 9 is a $9,000 sign-on bond through jail. Position number 10 is a $2,000 SOB through jail. Position number 11 is a $3,500 good bond. Position number 12 is a $3,000 good bond. Position number 13 is a $1,000 good bond. Position 14 is a $4,000 sign-on bond through jail. Position 15 is a $2,000 sign-on bond through jail. Position 16 is a $3,500 good bond. Any questions, concerns, or comments?
You got the add-on?
The add-on, yeah.
Yes. And the add-on, position number 1 is a $1,000 good bond. Position number 2 is a $2,000 SOB through the jail.
Let me make sure. Did you say on 14 is a 4,000?
14.
Is it 14 or 4?
Number 14, I have 4,000 SOB through the jail.
I think I got my 4s and 14s mixed up.
And number 9 was 4,000. It was 9,000 jail.
Number 9, 9,000 SOB through the jail.
Right.
4,000. Okay.
And then 10, and I'll leave you alone.
No problem. 2,000 SOB through the jail.
Okay, I heard correctly. Just making sure.
And Judge, I'm sending them over right now. I just scanned them.
Yes, ma'am. Thank you.
Thank
All
you,
right, everyone,
Judge.
enjoy the rest of your weekend.
Judge, you on Monday, right?
I know. Monday, they better act good this weekend.
Yeah, I'll see
We'll
y'all
see what Monday holds. Oh, that's right. You work Saturday, you're off Monday.
Yes.
Lucky you.
Thank you,
We'll all
Judge.
be
Have a
here.
great
All right,
day.
you all take care.